Are we on? Okay, we're now on the record. I guess before, is everybody here, are all the lawyers present? Mr. Spinard.
Good morning, Mr. Chairman.
All right, Mr. Miller, is Mr. Miller here, or Mr. Childers?
Good morning, Your Honor.
Morning, Mr. Childers. Mr. Miller. All right.
Good morning.
Before we start, I wanted, I guess, to discuss a couple of things. One, our time between now and the 13th, 14th of January, we have 3 holidays, and the holidays include the day before. So we've got Thanksgiving the day before, Christmas the day before, and New Year's the day before. And the way it's scheduled, there's not a lot of, we only have, 14, 15 days after any kind of reasonably even short scheduling order to get a decision out in the case. So yesterday I started working on a procedural order on the dates for data requests, response, and briefs, and it's kind of short, but I showed it to staff counsel, who's going to be in staff counsel and the rest of the staff in terms of doing the work, and she suggested that it even be shortened a couple more days. So let me tell you what the scheduling order is going to be, so that you can be thinking about it now. Data requests must be filed by end of day, midnight, whatever, December 1st. Responses to data requests, December 9th. Okay? Now, because we're running into time problems here, the day before, those data responses must be filed by Kentucky Power. Kentucky Power's brief will be due on December 8th. All right? Briefs for the intervenors, December 14th, and then Kentucky Power will have through December 17th to file a reply brief. But I know Kentucky Power has, 4 or 5, 6 lawyers, and the others, Attorney General has several, 2 at least, and the others, at least for the solars, joint intervenors, and Sierra Club, our interests are probably fairly well consistent. So in any event, if we don't do that, we won't have enough time to get an order out. And most of the time these orders in the electricity rate cases will go over 100 pages. So I'm sorry, I wish there were more time, but there isn't. And the holiday season complicates it.
Your Honor, this
Yes.
is Ms. Glenn. May I make one suggestion, if that would be all right? I noticed in the recent Duke rate case, which was also a fully litigated case, that the parties filed simultaneous briefs, and then Duke had 3 or 4 days to file a reply brief.
They may have filed simultaneous briefs with reply briefs. I don't I don't like simultaneous briefs. Because then there's something that somebody hasn't thought of, and then you come back and you say, well, I've got to file a reply brief, and you don't have much time. Look, we're going to do it this way: the brief, the responsive briefs, and then a reply brief, and that gives Kentucky Power the opportunity to have the last opportunity to make an argument on the briefs. Other things this morning, I guess, were what would be, after we finish with Mr. Vaughn, what will be the order of cross-examination for intervening witnesses. And I thought about that yesterday, and we'll just go down to the next party below the intervenor and do the, and the counsel for that next party will cross-examine, with the exception that Kentucky Power will always have the last opportunity to cross-examine the witnesses, because that way they will be able to have heard everything that the other witnesses have said. I think Mr. Fitzgerald has a conflict or something this morning. Is that right, Mr. Fitzgerald?
Good morning, Mr. Chairman. I'm fine. So you go ahead and manage this case as it needs to be managed, and I will make do if I need to multitask for a minute. I've just got a status conference and administrative hearing that is purely a scheduling matter, so I can do both at the same time.
Okay, all right. You may have an earpiece in each ear. And a microphone.
Exactly, and
All these
I will
old
try
movies that
not-
everybody's talking on two telephones at the same time.
I will try to multitask without my head exploding.
All right, is there, at this point, before we start, is there anything else anyone would like to bring to our attention before we begin? We'd like to finish today if possible, so let's see, and my schedule is such that I can't go much beyond 5 o'clock, so, but if we can't, we'll just come back tomorrow and keep going. So at this time,
Commissioner, I had a question briefly. This morning, Ms. Vincel asked the parties to provide feedback on whether there was any cross for certain witnesses and how much they expected. I don't know if she'd heard from everyone, but was just curious if there were certain witnesses for whom no one had cross, and we might just admit them into the record. And although it's not much time, it might dispense with a little bit of time to the extent there wasn't anyone.
well, I suspect, Ms. Goodman, that no one will have cross for your witness, but why don't we see right now if any counsel has any cross-examination or intends to cross-examine Walmart's witness, and if not, does anyone have an objection if her witness then is excused and does not have to appear?
Your Honor, this is Mike West for Attorney General's Office. We do just have a few questions.
Okay, all right. Well, Ms.
Thank you.
Drummond, we'll have you, she'll get on today, one way or the other. Okay. All right. Okay, Miss Bland, are you prepared for redirect, Mr. Vaughn?
I am, Your Honor. Thank you.
Thank you. You may proceed.
Thank you. And if I could ask staff to please display Company Exhibit 2, Company Hearing Exhibit 2 at page 11 of 25. Mr. Vaughn, if you'll turn to that document as well, please.
Ariel, that's Kentucky Power Exhibit, thank you.
Thank you. Mr. Vaughn, good morning.
Morning.
Do you recognize this document?
Yes, I do.
And what is it?
It is the Commission's order and settlement agreement from PSC case number 2004-00420, which we have been referring to as the words just escape me, the Rockport Unit Power Agreement extension.
Thank you. And were the AG and KIUC parties to this agreement?
Yes, they were.
Thanks. And if you'll turn to page 14, and if staff will please navigate to page 14 of the document, directing your attention to section 3.1b. If you'll read that for yourself, is this a provision that relates to the $6.2 million annual additional revenue that the company is entitled to collect through the capacity charge in 2021 and 2022?
Yes, it is.
Thank you. And if we can please navigate to page 15. And if we'll scroll to the bottom, section 3F, as in Frank, begins at the bottom of page 15 and carries on to page 16. Will you please read that provision?
Certainly. This stipulation and settlement agreement is made upon the express agreement by the parties that the receipt by Kentucky Power of the additional revenues called for by section 3.1a and 3.1b shall be accorded the rate-making treatment set out in this section 3. In any proceeding affecting the rates of Kentucky Power during the extension of the UPSA, under this stipulation and settlement agreement, the provisions of this Section 3 are an express exception to Section 6.4 of this stipulation and settlement agreement.
Thank you. And will you please turn to page 17, and if we could navigate to page 17, will you please read section 6.4,
Yes.
which is at the bottom of that page?
This stipulation and settlement agreement further is made upon the express understanding that it constitutes a negotiated settlement, and except as otherwise expressly provided for herein to effectuate this stipulation and settlement agreement, no party shall be deemed to have agreed to any rate-making principle, precedent, or policy, nor shall any party be deemed to have agreed or consented to any matter not expressly stated in this stipulation and settlement agreement. Nothing in this paragraph is intended to prevent the admission of this stipulation and settlement agreement as evidence in any proceeding in which it is relevant.
Thank you. So taking these three pieces and putting them together, do I have it right that the 6.2, we read 3.1F, and it says that the $6.2 million the company is entitled to collect through the capacity charge is an exception to section 6.4, which you just read.
Yes, that's my understanding of what the words say.
And I, recognizing you're not a lawyer, I'm not asking you for legal opinion testimony, but you have been questioned about this agreement by other counsel and the vice chairman in this case, I believe, definitely by other counsel. Do I have it right that, in other words, the AG and KIUC have expressly agreed to Kentucky Power's receipt of the additional revenues collected through the capacity charge and to the rate-making treatment of those revenues in the settlement?
Yes, that's my understanding as a rate-making professional, that they have agreed to the receipt by Kentucky Power and the rate-making treatment as we proposed in the base case.
And in your opinion, as a rate-making professional, is it appropriate for those parties to now argue against the company's receipt of the capacity charge revenues or the rate-making treatment of those revenues in this case?
From a non-legal standpoint, it would seem inappropriate.
Thank you. If staff could now please display Kentucky Power's application, section 2, exhibit E. At page 208. And while staff is pulling that up, Mr. Vaughn, do you recall questions from Mr. Spinard and Mr. Fitzgerald yesterday regarding the company's tariff EDR?
Yes, I do.
Is it your understanding, Mr. Vaughn, and if we could please scroll down just a little bit to item 3 under availability of service. Mr. Vaughn, one of the requirements of service under tariff EDR is the customer demonstrate to the company's satisfaction that absent the availability of the EDR, the qualifying new or increased electrical demand would be located outside of the company's service territory or wouldn't be placed in service.
That's right. They're stating that in order to get the EDR discount, they would not have otherwise cited in the company's territory, but for the provisions of the EDR tariff.
Thank you. And did the customer who was taking service under tariff EDR during the test period provide a statement to that effect to the company?
Yes, they did.
And is it your understanding that Kentucky Power included the customer's application for service under the tariff, which included that statement, in the company's application for approval of its tariff EDR agreement with that customer in case number 2018-378?
Yes, the company did, as well as the marginal cost of service study that is also a requirement of tariff EDR.
And the company or the commission approved that agreement based on the record in that case.
Yes, it did.
Now, in your opinion, could a net metering customer satisfy either the requirement under requirement 3 under availability of service or the marginal cost requirement?
No, they wouldn't be able to satisfy either. Obviously, they're already here as their residential customer. They're simply adding a system to their load, so they, that would not work for them. And also, they would not pass the marginal cost of service standpoint, as I've testified and I've shown in my rebuttal testimony. It's the exact opposite. Their reduction in cost is less than the reduction in revenues received from that customer when they add a system. So it's the exact opposite of an EDR customer, where the addition in cost by definition has to be less than the additional revenues received from the additional load, right? We're talking additional load versus reductions in load.
Thank you for that clarification and explanation. Want to turn now to EEI. There's been discussion over the last several days about the company's membership dues for its membership in EEI. Have you heard that discussion?
I have heard several discussions about that, yes.
Can you please describe your involvement on behalf of AEP in EEI?
Yeah, so on my team, we have individuals that do various rate case filings and compliance filings and other things in all of the company's eastern states, and I guess all of our states actually when we take fuel into account. And I myself and some of my managers participate in the rates committee portion of EEI, and in a, when we go to those meetings, we the form of continuing education and training where we can discuss various rate making and cost of service issues with our industry peers. So it's a valuable training tool. And in a normal year, I like to send as many folks as I can from our teams at various levels of progression to the various trainings the EEI provides, as part of membership, so we can continue to continue the continuing education of our team and have well-trained individuals that are well-rounded and gain broader experience than just their work for the AEP companies. Also, it's my understanding that EEI, provides support to other professional organizations such as NARUC and some of the consumer advocate associations as well.
And is it your understanding that EEI members' dues, including AEP's dues, pay for those NARUC and NISUCA and other activities that are provided to regulators and consumer advocates and others outside of the utility?
That's right. Our dues to EEI allows them to then financially support other training opportunities. Correct.
Thank you. And we can take down the company's application. I should have clarified that earlier. Thank you. Mr. Vaughn, you recall questions from Mr. Fitzgerald regarding the Net Metering Act, KRS 278-465 at SEC,
I do.
specifically regarding whether the company's proposed bill credit in tariff NMS2 constitutes compensation to customer generators. Do you recall those questions?
I do, yes.
And do you have in front of you a copy of KRS 278-466?
I do.
The first sentence of 278-466, Section 3, provides that a retail electric supplier serving an eligible customer generator shall compensate the customer for their generation. Is that correct?
That is exactly what the words say.
Can you please take a look at 278-466, Section 4, and read the first sentence of that section?
Yes. Each billing period, compensation provided to an eligible customer generator shall be in the form of a dollar-denominated bill credit.
And is that what the company is proposing in this case in tariff NMS2?
That is exactly what the company is proposing in NMS2 with the avoided cost rate.
Recognizing that you're not a lawyer, is the word shall, do you interpret the word shall in that sentence to be mandatory or permissive?
Mr. Chairman, I'm going to interpose an objection. If council wants to brief the issue, we can brief the issue, but this selective recitation of what the statute says is not appropriate for this witness. This is a matter of statutory interpretation that is a matter for lawyers and is a matter for this tribunal, and is better done during the briefing.
Well, Your Honor, Mr. Fitzgerald opened up this line of redirect with his questions to Mr. Vaughn about the meaning of the statute and what the statute required in terms of compensation, and the discussion yesterday about a bill credit versus cash to a customer generator. Mr. Miller from Sierra Club specifically asked Mr. Vaughn yesterday whether shall in subpart 1 of 278-466 was mandatory or permissive, or whether the language, in that provision is mandatory or permissive. So I'm simply exploring those concepts on redirect.
For me,
Mr. Chairman.
answer it for what it's worth. But in reality, if Mr. Vaughn were the finest utility lawyer in the world, in testimony before any tribunal, I don't know of anybody that allows a witness to testify what the law is. So I think the objection's well taken, but I'm going to let him answer the question in view of all of the other questions that he had to fend off for the last 2 days.
Thank you, Mr. Chairman.
So, Mr. Vaughn, is the word shall in 278-466 subpart 4 mandatory or permissive in your non-legal opinion?
In my non-legal opinion, when someone tells me I shall do something, it's mandatory.
Is this case, in your non-legal opinion, a rate-making process
Yeah,
during a proceeding initiated by a retail electric supplier?
yeah, absolutely. It's a rate-making process.
And it's one,
By Kentucky Power Company.
would a general industry proceeding, an administrative case, or a workshop type of docket, initiated by the commission constitute a rate-making process initiated by a retail electric supplier?
No, and it would be inappropriate in this sense. As I discussed in my my rebuttal testimony, a lot of the electric suppliers in Kentucky are very non-similarly situated in regards of what RTOs they belong to, what their avoided costs are. It's all very different. It should be utility specific.
And are you familiar with the commission's docket last year regarding the implementation of the Net Metering Act?
Yes, in December I actually participated.
Is it your understanding that the commission recognized in that proceeding that the determination of avoided cost rates for net metering customers needed to be made on a utility-specific basis?
That's my understanding of their order from that case.
Changing gears, you talked yesterday with the vice chairman about winter heating customers. Do you recall that discussion?
Yes.
What is the company proposing in this case to benefit winter heating customers?
As I've discussed in direct and rebuttal testimony, the company's proposed increase of the basic service charge, the addition of the winter heating tail block will both benefit winter heating customers and the large bills they incur during those months. In addition to that, the company has various assistance programs that it continues to maintain, as well as what I've called the debt forgiveness issue. The $10.8 million is still outstanding. There's definitely those accounts I think were as of May, so there's definitely some winter bill defaults in there that could be included in the debt forgiveness. And just in general, the company's proposal to put this rate increase off for another year with the first year offset.
Thank you. Specifically regarding the company's winter heating declining block rate, if that rate reduced the customer's bill hypothetically from $300 to $200, would that help that customer, in your opinion?
Yes, it's a smaller financial burden and it's more in line with cost causation, as I discussed at length yesterday, and it results in a reduced intra-class subsidy that customers pay.
Now, you and the vice chairman briefly discussed whether DSM type of programs might be available to help high winter usage customers. Do you recall that discussion?
I do.
Are you familiar with the Commission's January 18th, 2018 order in case number 2017-97?
I am, yes.
And can you please summarize your understanding of what the Commission directed with regard to DSM programs in that order?
Yeah, so in that order, besides the targeted energy efficiency program, the Commission ordered the company to cease all other EE and DSM programs and essentially barred the company from additional programs until it can show a capacity short or a capacity need in the future.
Thank you. When does the company expect that its capacity position will next indicate a need for additional generation to serve load?
Right now, we are anticipating that will happen after the Rockport UPA terminates in December of 2022.
So practically speaking, under that 2017-97 case order, non-low-income DSM is not permitted until 2023?
That's my understanding.
Could staff please display company hearing exhibit number 3 at page 85? And Mr. Vaughn, if you could also turn to that exhibit, please.
I have it.
Thank you. In the interest of time, I will represent that Company Exhibit 3 is the Commission's January 18th, 2018 order in case number 2017-179, which we have discussed multiple times over the last week and a half. And page 85, 122 is page 6 of the stipulation in that case. Do you recognize this document as that, Mr. Vaughn?
I certainly do.
Can you please read section 3F, as in Frank, of the stipulation?
Yes. If Kentucky Power elects not to extend the Rockport UPA, it will, beginning December 9, 2022, credit the Rockport fixed cost savings through the demand component of tariff PPA until new base rates are set. However, for 2023 only, the Rockport fixed cost savings credit will be offset by the amount, if any, necessary for the company to earn its Kentucky Commission authorized return on equity, ROE in parens, for 2023 parens Rockport offsets. An example of the calculation of the Rockport offset is included as Exhibit 2.
Thank you. Now, Exhibit 2 to the stipulation was filed with the stipulation in case number 2017-179, but it does not appear to have been attached to the Commission's order in that case. Are you familiar with Exhibit 2 to the stipulation in that case?
I am. I believe it's also included in the PPA forms that the company submits each year in its annual true-up.
Thank you. Can you please walk through how the ROE as approved by the Commission in approving the settlement is to be calculated for 2023 with respect to the Rockport fixed cost savings credit?
Yeah, certainly. It's there's line letters, I guess, for this exhibit or form in the PPA forms. It's line A is the 12-month GAAP net income. Line B is the 13-month average common equity, and C is the return on common equity, which is simply the 12-month GAAP net income divided by the 13-month average common equity.
Okay, so the numerator in that equation is the company's GAAP net income.
Yes.
Thank you. Do you recall discussions with the Vice Chairman about the company's earned ROE?
Absolutely.
Is it your understanding, do you have an understanding whether the company's earned ROE is calculated in accordance with GAAP and SEC rules?
Yes, that's my understanding, and I believe that's what we have presented in Company Witness Madison's rebuttal testimony.
Now, there was discussion yesterday about expense items not included in the last test year or not included in a rate case test year expense, and whether those were included in the calculation of earned ROE. Do you recall that discussion?
I do. The items that were agreed upon to not be included in rates in the last settlement agreement.
Would revenues that differed from the test year level of revenues be included in the company's calculation of its earned ROE?
Yeah, absolutely. Test year's a point in time, and rates are set based on a test year, and everything that happens after that's different.
So if the company's revenues were below the 2017 test year level of sales, say due to load losses, due to economic conditions, or post-test year load losses, post-test year in this case load losses related to COVID, would those impacts be included in the company's earned ROE calculation?
Yeah, those are exactly the kinds of things that are included in what Company Witness Madison has represented in his rebuttal testimony.
And I believe yesterday the Vice Chairman asked you about the company's recent storm deferral filings.
Yes.
And in that case, the company seeks authority to establish a regulatory asset for approximately just under $9.5 million in incremental major storm-related expense. Is that your understanding from the discussion yesterday?
That is what I recall, yes.
What impact on earned ROE does $9.5 million in expense have?
I believe it's roughly 100 basis points. I think that's included in that application as well.
Thank you. So a roughly $10 million swing in expense represents 100 basis points in actual earned ROE for the company.
Yes.
Are the expenses that you discussed with the vice chairman yesterday that were not included in test year expense in the last rate case significant enough to materially change the company's earned ROE calculations as presented in Madison's testimony this evening?
I'm sorry, you'll have, Mr. Bland, the reporters are having difficulty understanding you. Could you maybe slow down on asking the questions and speak louder? The last question,
Sure.
they found, they couldn't interpret it.
I'm sorry, Your Honor. Yes, this is, I believe, my last question, and I will slow down and speak directly into the microphone. Thank you. Mr. Vaughn, are the expenses that you discussed with the vice chairman yesterday that were not included in the company's 2017 text year expense significant enough to materially change the calculation of the company's earned ROE as presented in Mr. Madison's testimony in this case?
No, they're not.
Thank you. I have no further questions at this time, Your Honor.
Okay, thank you. All right, Mr. Vaughn, at long last, you may step down, and since Mr. Madison is the only other company witness that may be recalled, you're excused. And thank you for your testimony over the last, 2.5 days, perhaps. Ms. Bland, is Mr. Vaughn the last company witness?
He is the last company witness, Your Honor. Thank you. I do have a couple of items with regard to exhibits to address, if now would be an appropriate time for that.
Now would be fine.
Thank you. The commission previously admitted a document that was pre-filed as Company Exhibit 8, but it was admitted into the record of this case as Company Hearing Exhibit number 1. So with respect to our other exhibits, we discussed with Mr. Vaughn the document that was pre-marked Company Hearing Exhibit number 1, which were the revisions to the revenue requirement and that he walked through on direct. I think the cleanest way to handle that exhibit would be simply to make it Company Exhibit number 8, just to swap it with the one that became Company Exhibit 1. So could we redesignate what has been marked Company Hearing Exhibit 1 in Mr. Vaughn's direct testimony as Company Exhibit 8?
Why don't we just mark it as Company Hearing Exhibit 1, and then in parentheses put, Record Exhibit 8 or just Exhibit 8 on it. That way we can, I don't know what else, might be admitted, but I know you can refer to it either way, but there was always, it seemed like a practice in past years of referring to exhibits in the record at the hearing, but not putting them into evidence at the hearing, even though they were already in the record that could be considered. But it's easier sometimes when you have a record to be able just to have the exhibit there and refer back to it. So I think we ought to leave it Exhibit 1, but designate it as Record Exhibit 8 or something, so that there won't be any confusion about it.
That would be fine, Your Honor. Thank you. So with that clarification, I'll move for admission of Company Hearing Exhibit 1, which is Record Exhibit 8.
Okay, sustained.
And I would also like to move for admission of Company Hearing Exhibit numbers 2 and 3.
Sustained, that's fine.
And then finally, Your Honor, Company Hearing Exhibit number 7, which were 2019 project statistics from PJM, were discussed and utilized during the examination of company witness Pierce last week, I believe on the 18th. And we inadvertently did not seek that document's admission then, so I also move for admission of Company Hearing Exhibit number 7.
Sustained. Will all be admitted as hearing exhibits.
Thank you, Your Honor. I have nothing further at this time.
All right, counsel for the Attorney General's office. Mr. West, do you have, I don't know if Mr. Cook's here, but Mr. West, do you have witnesses?
Yes, we do have witnesses, and our 3 witnesses are being shared with KIUC, and Mr. Kurtz is going to handle the introduction of our first witness, Mr. Collins.
Okay, Mr. Kurtz, who is your first witness?
Lane Collin, Your Honor.
Mr. Collin, would you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. You may ask, Mr. Kurtz.
Mr. Collin, will you state your name and business address for the record, please?
My name is Lane Collin. My business address is J. Kennedy and Associates Incorporated, 570 Colonial Park Drive, Suite 305, Roswell, Georgia, 30075.
Did you file direct testimony and exhibits in this case, as well as data responses?
I did.
If I were to ask you the same questions, would your answers be the same?
Yes, with certain exceptions.
Do you have some corrections or additions to your testimony?
Yes, I do. On page 20, lines 6, 7, 8, and 11, I have changes. I'll wait just a few seconds until people get to that page, page 20. Page 20, line 6, the term net 2 should be changed to reflect, the word reflect. On line 7, the amount of 45.500 should be 45.940. On line 8, the amount 19.143 should be 2.107. And then on line 11, the word "are" should be changed to amounts net to. Those are all of the changes that I have on page 21 or 20. Then on page 37, line 3, there's a percentage, 45.45%. That should be 45.35%. Page 45, line 17, insert the following: $57.4 million fixed cost. And on line 18, replace the word rate making with per books. And then finally, on line, page 54, line 3, the year 2020 should be 2021. And on line 5, the amounts should both be changed to 27.689. So instead of 19, it should be 27.689. Both references to that amount.
Are those all the corrections?
Yes.
Your Honor, appended the witness for cross-examination.
Thank you.
Chairman, before we move on, can I make a request of the AG and KUC, the same request I made Ms. Glenn for Mr., given the number for Mr. Vaughn's testimony, could the company file, or the AG and KUC file an errata version reflecting those changes in the written record?
We'll certainly make that happen.
Thank you.
Okay.
I apologize.
Will Tina Frederick be doing the cross-examination for
Yes,
staff?
yes, Chairman, Ms. Frederick will do that.
Ms. Frederick, good morning. It's good to see you.
Good morning, Mr. Chairman. Good to see you.
Are you prepared to cross-examine?
Yes, I am. Thank you, Mr. Cole. Good morning.
Good morning, Ms. Frederick.
In your testimony, you proposed to allocate the Mitchell coal stock adjustment proportionally across the capital structure. If Kentucky Power uses only short-term debt for its coal purchases, how would you propose to allocate the Mitchell coal stock adjustment?
First of all, Mr. Vaughn said yesterday that the company's proposal was to allocate the Mitchell coal stock adjustment across all of the capital structure components. That isn't correct. So I want to first address that. The company asserts that its coal stock is financed with short-term debt. There's no evidence of that. The company's financing is not painted. In other words, it doesn't borrow short-term debt solely for the purpose of acquiring coal inventory. We've addressed this in prior cases, and the company has in the past even sought to have a negative amount of short-term debt under that incorrect presumption. But essentially, to respond to your question, if the company finances coal stock with short-term debt, this is simply not correct, and there's no evidence to that effect other than Mr. Vaughn's assertion to that effect. But if that were the case, then I think the commission ought to consider what other costs are financed with short-term debt and whether or not there should be a direct assignment of the short-term debt. And quite frankly, we meaning KIUC, I don't believe that I represented the AG in some of the environmental cases, but KIUC in some of the environmental cases has argued that short-term debt should be reflected in the environmental surcharge. And the commission has, on a preferential basis, and the commission has determined that the company's financing cannot be segregated in that manner. That was a little bit of a long answer, and I apologize for that, but I just wanted to respond to Mr. Vaughn's assertion and then his rationale for an adjustment that he apparently doesn't realize that the company made, which I'm a little surprised at. So anyway, I'll shut up now.
Thank you for your answer. And you suggest adjusting the short-term debt balance to more accurately represent the short-term debt balances throughout the entire test year as opposed to test period ending balance?
Yes, that's correct, because I think that's more consistent with the reality of the test year, the historic test year. And also, then I would propose using a current interest rate on that short-term debt because that is what it currently costs the company. And that actually is much lower cost. It's about 0.5% right now compared to the cost of bank term loans or other long-term debt.
If the short-term debt balance was adjusted as you proposed, would it be reasonable then to allocate the Mitchell coal stock adjustment proportionally?
Yes, proportionately, including the increase in the short-term debt. And remember, that's what the AGKIUC recommendation is, to allocate the Mitchell coal stock adjustment, which is an adjustment to reduce the amount of coal inventory included in rate base or in capitalization down to a target level. And it is the AGKIUC recommendation to do that across the board, across all capitalization components. And if the short-term debt is greater, then it would have a larger proportion in the capital structure. But it doesn't, it's consistent with the overall principle of allocating it proportionally across the capital structure.
Okay, let's turn our attention now to interest rates. Given the current interest rate environment, do you still believe that 4% is an appropriate proxy for the cost of new debt in June 2021?
I think a strong argument could be made for 3% based upon the present interest rates over a variety of tenors, meaning the duration of the debt issued, whether it would be 5-year debt, 7-year debt, 10-year debt, or 30-year debt. And I provided a response to staff data requests that provided a copy of the Mergent Bond Record, which provides the cost of long-term 30-year debt for utilities at a BAA rating, which would be roughly consistent with what Kentucky Power's debt rating is, and it's right around 3%, 3.1% or so. So that actually would be better than 4%, but anything in that range I think would be acceptable. And then under the AGKUC proposal, there would be a true-up to the actual cost when the debt is actually refinanced in July of this year, or July of next year.
Thank you for your answer. Your Honor, I have no further questions for this witness.
Okay, Ms. Grundman, questions?
No questions, Your Honor.
Mr. Spinard,
Good morning, no questions.
Mr. Fitzgerald,
No questions, Your Honor.
Mr. Miller,
None from Sierra Club, Your Honor. Thank you.
thank you. Mr. Fry,
No questions, Mr. Chairman.
Mr. Overstreet. No, I suppose let me ask the commissioners first, and then give Mr. Overstreet the last chance. Vice Chairman Chandler, questions?
Thanks, Chairman. I do just have a question on a singular issue, Mr. Collin. Good morning.
Good morning.
On the issue of the pension and OPEB prepayments, have you read Ms. Whitney's rebuttal testimony in that regard?
Yes.
Are you aware of her, and I referred to it the other day as an alternative argument, but Ms. Whitney didn't correct me that wasn't an alternative argument, but are you aware of her reference at the end of her rebuttal testimony where she discusses if the commission does remove pension and OPEB from rate base, or doesn't include it in rate base, that the commission should also remove the ADIT associated with those? Do you remember her saying that?
I do. That was an issue that I raised in my direct testimony. It's an error in the company's filing, and one that Ms. Whitney conceded, actually in response to discovery, to the AGKUC discovery, and then conceded it in her testimony. And keep in mind that there's a positive amount in account 165 that, under the company's very atypical, highly unusual accounting, but they put a positive amount in and then an equivalent negative amount, so the two net to zero. And then there are related ADIT amounts. So for the positive amount in account 165, there's a negative ADIT, a liability ADIT. For the negative amount in 165, there's a positive ADIT. So if you're not going to include the negative amount in 165, then you need to take the positive ADIT out. And the company agrees with that. So that would be a correction of an error.
Okay, and that's why I want to make sure that I'm sort of clear of that alternative. We'll call it an alternative. That may not be correct, but that mention at the end that if one is going to be excluded, then the ADIT offset should be excluded. There is no difference in daylight between your recommendation or the AGKUC's position on that issue and the company's. Is that fair?
That's correct. If in fact the prepaid pension is left in rate base and the prepaid OPEB is left in rate base, if it's taken out, then the two ADIT amounts just net to zero, just like the positive and negative amounts in account 165 net to zero. So if you take out the 165 prepaid pension and prepaid OPEB, misnomers to say the least, if these are taken out of rate base because the negatives are not included by the company in rate base, then you don't really need to do anything with the ADIT because it just nets to zero anyway. But if you leave the positive prepaid pension and OPEB amounts in rate base, then you need to take out the positive ADIT associated with the negative amounts that are not included in rate base. So there's no daylight between us and the company if, in fact, you include the prepaid pension and prepaid OPEB in rate base.
Let me ask, the only other question I have is the sales of electricity in Illinois and Michigan. And the salary expenses in West Virginia. If the company is allocated the company themselves, right? If they receive an actual expense, income tax expense for those sales of electricity in Illinois, Michigan, and the 21%, I think, of the 21% of that is the allocation or the income tax expense from West Virginia. Do you agree or disagree with the company on that issue?
I don't agree, and I, first of all, haven't seen any evidence to that effect. My understanding is that the income tax expense for Kentucky is based upon an income tax filing, an income tax return in Kentucky that takes the Kentucky taxable income and applies a 5% Kentucky state income tax rate. Any income tax expense in any other state is not allocated to Kentucky. There's no bill for it or anything like that. In other words, this is a pro forma type of adjustment that is reflected in the company's filing that I don't think is consistent with the reality.
Okay. Those are all the questions I have for Mr. Collin. Thank you, Mr. Collin.
Dr. Matthews, questions?
I don't have any questions for this witness.
Okay, Mr. Overstreet, redirect.
How about cross-examination? Your Honor?
Cross-examination, I'm sorry. You've been going for 5 days, so
I understand. I woke up this morning and wasn't quite sure where I was. Unfortunately, that's my growing experience as I merge into my dotage. But good morning, Mr. Collin.
Good morning, Mr. Overstreet.
Would you please turn to pages 54 to 58 of your testimony?
Yes.
And at those pages, that's where you recommend that the commission terminate tariff CC capacity charge and the rates associated with it. Is that correct?
You said pages 54?
54 to 58.
I think that actually starts on page 55, but yes.
Okay, I'm sorry. The heading is on 54. That's my bad.
Yeah, you're right. That's the only reason that it would start on page 54. Yes.
But wherever it starts, you recommend that the commission terminate tariff CC and the rate established by that tariff. Is that correct?
Yes. Essentially, that's the company's proposal. Subject to the condition that the commission makes no other changes to the company's filed case. But I essentially recommend that the commission reject the condition but accept the company's offer.
And Ms. Venzel, could I ask staff display Kentucky Power Exhibit 2, which is the order from the case number 2004-00420. Thank you. Do you recognize that, Mr. Collins?
I do.
And attached to that order was Appendix A, which was the stipulation and settlement agreement entered into by your two clients in this proceeding, the Attorney General of the Commonwealth and KIUC. Is that correct?
Yes, that's correct. And it was signed by the company too. And of course, the company is in this case proposing unilaterally to modify that settlement agreement in that particular term, which we agree with, except for the condition that the company wishes to impose.
Okay. And you would agree that the order itself, which was entered on December 13, 2004, approved that stipulation and settlement agreement without modification?
It did.
Okay. Would you please turn to page 12 of the exhibit, which is page 2 of the stipulation and settlement agreement? I apologize, I need to get there myself. And do you see the whereas clause that starts at the bottom of that page and continues on to the next page of the stipulation and settlement agreement?
At the bottom of page 2,
Right, it starts off, whereas the commission in its March 29, 2004 and March 29, 2004 orders in administrative case number 387.
I see that provision, yes.
Okay, and isn't it true that in that whereas clause, your clients, the Attorney General of the Commonwealth and KIUC, recognized that the commission had directed Kentucky Power, quote, to continue to seek extensions of Rockport Unit Number 1 and Rockport Unit Number 2?
I think those whereas paragraphs are intended to be a statement of facts that the parties agreed to.
Thank you. And then there's a whereas clause, if you could just scroll down a little bit more, please. It immediately follows the one we just discussed, where your clients agreed, quote, that the extension of the USPA for 195 megawatts of Rockport Unit Number 1 and for 195 megawatts of Rockport Unit Number 2 is in the best interest of Kentucky Power's ratepayers and will enable Kentucky Power to secure long-term, low-cost, coal-fired base load generation, end quote.
What is the question?
Do you agree that that's what your clients agreed to as a statement of fact in the whereas clause?
That's what the clause reads.
Okay. And then would you agree in the next whereas clause, which starts out, whereas the parties agree that the additional revenues called for under this agreement are, quote, fair, just, and reasonable consideration for the extension of the UPSA for Rockport Unit Number 1 and Rockport Unit Number 2 and the resolution of the other matters resolved, end quote, through the agreement.
I think you pretty much read that correctly. And, you know, the parties include the company, I might add. I know that is risking some redundancy here, but the company was a party to this agreement and agreed with these statements as well. And yet it's offered in this proceeding to modify the terms of this stipulation and settlement agreement.
And so you would agree that the company in making that offer is giving up approximately $6.2 million a year through the end of the Rockport Unit Power Agreement.
It would forego its opportunity to recover $6.2 million through the capacity rider.
And your clients are giving up nothing through your position, right?
I don't think that's true. Our clients have conceded considerably, increases in costs. There have been significant changes in the anticipated operation of the Rockport agreement, where Kentucky Power has had taken no opportunity to stand for the customers in Kentucky, while AEG Co. and Indiana and Michigan renegotiated the agreements pursuant to and entered into consent agreements and made the decisions to, for example, install an extremely expensive SCR and to modify other system operations at Rockport 2 and impose the cost on Kentucky Power. So there have been really significant changes since the stipulation and settlement was entered into, and Kentucky Power has not at all protected its customers from the increased costs resulting from the decisions that other parties to the agreement have made.
Well, would you look at the, we were just discussing the $6.2 million that Kentucky Power was giving up through its conditional approval, and the fact that your clients had agreed that those, what became tariff CC and the resulting $6.2 million, your clients agreed that they were fair, just, and reasonable rates. Is that not correct?
What we're agreeing to is we accept the offer and we agree with it to concede the $6.2 million. And part of that is, we agree that there should be a rate increase in this case. We agree that the company, we continue to agree that the company should retain some of the fixed cost savings when the Rockport UPA terminates in December of 2022. So, the company, because of its inaction and failure to really represent customers in its interaction with AEGCO in Indiana and Michigan, we have had costs imposed on us, significant costs, through the environmental surcharge and through the base revenue requirement. So we've given up a lot, I think.
So, but there's nothing in the agreement that makes those exceptions to, of course, I'll disagree with your characterization, but nevertheless, that makes those exceptions get out of free, an exception to the statement that the $6.2 million is fair, just, and reasonable.
Well,
there is, please point to me in the agreement where it says that.
Yeah, there's no specific paragraph that allows any party to unilaterally change the agreement, but yet the company has come in this case and proposed a change to the stipulation and settlement, which is beneficial to customers, and we agree with that.
Okay.
But there's no specific provision that says the company is either required to or even allowed to, but the company has.
So it's, I'm sorry, I didn't mean to.
I just was reiterating that point, that's all.
So could you turn to, and then we're in the same document, but we're going back. It's page 6 of the order, so that would be page 6 of the PDF. And Mr. Collin, do you see the paragraph that starts, the commission previously expressed serious concern in the middle of that page?
I do see that, yes.
Okay. And it says, if I may read it, the commission previously expressed serious concern what had been for some time Kentucky Power's intent to meet its native load requirements by purchasing power at market-based prices rather than extending the Rockport unit power agreement. See that?
I believe that you read that correctly.
And do you disagree, or do you believe the commission was wrong in its characterization of its serious concern?
I can only read what you read from that document. I don't know what the commission's intent was or what its knowledge was at that time. I simply don't know.
And then you see right below it, the commission in its own order excerpts a portion from its order in administrative case number 387. See that double indented quotation?
I do see that, yes.
And that quotation says AEP Kentucky must plan to meet its load by securing sufficient capacity that is not subject to market price volatility. Only by doing so will AEP Kentucky be able to maintain reasonable electric rates while mitigating to the extent possible market price and fuel price fluctuations. Do you understand AEP Kentucky in that quote to be Kentucky Power?
I do understand that to be the case. And of course, that was before the rise of PJM and the market, RTO market structure.
And do you think that the commission, when it wrote that in administrative case number 387, was mistaken?
I don't know what the commission thought at the time or what its intent was, other than through the express wording of that order.
If we could turn to the next page, which would be page 7 of the PDF and page 7 of the order. And the paragraph about in the middle of the screen, it starts off, the commission, thank you. The commission further finds that the proposed modifications, I'm sorry, I've gone too far. Then the next sentence starts, Kentucky Power has previously indicated that it's unwilling to extend the Rockport unit power contract, and as a wholesale power sale, the commission has no jurisdiction to require the extension of that contract. Do you see that?
I do see that.
And then below that excerpt, I'm sorry, let's go back, if we could scroll back up to page 6 now. Right, thank you. Where it starts, consistent with these commission findings, the commission wrote, Kentucky Power is now proposing a long-term extension of the Rockport unit power contract at a price that is not subject to market volatility. Do you understand that?
I'm having a little trouble responding yes or no to that question. Do I understand that? I can see that that's what the language in the order states. If I could somewhat modify the question.
And then it continues, although the price to be paid by retail customers for this power does reflect market prices, since it's priced above the cost of service, the price now being fixed will insulate retail ratepayers from the risk of future market price volatility. You understand the commission to have found that?
Well, I can see that that's what's written in the order. And of course, the facts and circumstances have changed significantly with the rise of the PJM RTO and market pricing for capacity and energy.
I'd like to ask you some questions about the settlement agreement itself. Was AEP Generating Company a party to the settlement agreement signed by your clients?
I don't believe so.
And is it not true that the amounts paid under Tariff CC are paid to Kentucky Power and not AEP Generating?
Yes, that's correct.
And that AEP...
Of course, there is a relationship there. In other words, one of the paragraphs or one of the provisions of the settlement agreement addresses the eventuality or the possibility, I think probably might be a better word, the possibility that the Kentucky Commission would not provide recovery in the future of the $6.2 million. In that case, Kentucky Power basically preserved its right to go back and extricate itself from the UPA. And so I think that was a provision that has been overlooked in this hearing so far, but it's an important provision.
Excuse me, Mr. Collin, I didn't mean to cut you off. Are you finished?
I'm finished, thank you. Yes.
But my question was, are the amounts paid to Kentucky Power?
And I answered that yes.
And are Kentucky Power and AEP Generating separate legal entities?
They are, but they're contractually bound together with respect to Rockport.
And does the Kentucky Public Service Commission regulate AEP generating?
It does not.
Can we turn to pages and don't start with pages 31 to 33 of your testimony? That's where you address SERP. Let me know when you get there, Mr. Collins.
Yes, that's correct. I'm there.
SERP is an acronym for Supplemental Executive Retirement Plan.
That's correct.
And Ms. Vinsel, can we call up Company Exhibit 3, which is the order, January 18, 2018 order from case number 2017-00179?
Yes, we'll do that. Thank you, Mr. Overstreet.
Now, before we turn to that, Mr. Collin, I want to ask you a question about your testimony. As I read your testimony, you cite 4 cases. Is that correct? Footnotes 46, 47, 48, and there's an id in 49.
Yes, that's 3 companies, with the 4th footnote referring to the 3rd company a second time.
But you, and if we could turn to page 16 of the commission's order now. Did you review this before filing your testimony, Mr. Collins?
I did, just as I reviewed the portions related to incentive compensation.
Right. And isn't it true that the commission approved the company's supplemental executive retirement plan expense in the last rate case?
It did, and of course it disallowed the incentive compensation expense tied to financial performance, and that was not apparently an obstacle to the company coming in and requesting it again, even without a citation to this order in which it was denied.
But you,
So that's what we're trying to, juxtapose. I think that all of these issues really are straight up on the table for consideration in this case. I don't think I'm under an obligation to ask the commission for reconsideration. I'm asking them for consideration in this case for denial of the SERP expenses. Just like the company is asking for consideration, didn't ask for reconsideration of the incentive compensation tied to financial performance. Issue up front on the table in this case, regardless of the commission's prior decisions.
and I understand your position, but you did find it relevant to cite a 30-year-old LG&E case, right?
I did, because there's a mixed experience with the commission, mixed decisions on this issue.
Ms. Vinsel, can we now call up Ms. Kaiser's rebuttal testimony in this case? Page 12.
Yes, Mr. Overstreet. It may take 1 moment. Thank you for your patience.
I'm not going anywhere.
Mr. Overstreet, neither am I. So we're aligned on one issue, right?
That's right. Thank you. Mr. Collin, may I direct your attention to line 12 of page 12 of Ms. Kaiser's rebuttal? And it's the sentence that starts about halfway over the AEP system. Thank you. The AEP system's non-qualified pension plans use the same benefit formulas as are used under the qualified retirement plan for each respective employee, except that the non-qualified benefits are reduced by the amount of the qualified benefits. Do you see that statement?
I do.
And you did not file any study or evidence to the contrary, did you?
I didn't have the opportunity for rebuttal testimony. And I don't think it's relevant to the issue in any event.
You don't think it's relevant, notwithstanding the fact that the commission pointed to the fact in its 2017 order?
What do you mean, the fact? I'm not sure what the reference is to the fact.
That's fine. In that order, on page 16, the commission wrote, Kentucky Power stated that the total benefit it provides under both its qualified and non-qualified plans is equal to the benefit that would be produced by the formulas utilized under the qualified plan.
Mr. Overstreet, the reporter just said she could not understand you. Could you repeat the question, start from the beginning?
I apologize to. I am starting over now.
Okay, thank you.
The commission in its 2017 order wrote, Kentucky Power stated that the total benefit it provides under both its qualified and non-qualified plans is equal to the benefit that would be produced by the formulas utilized under the qualified plans. These plans were not subject to the benefit limitations imposed on the qualified plans. And then my question was, Mr. Collins, did you introduce any evidence to the contrary, or do you have any evidence to the contrary today?
No, I did not address that particular aspect of either the commission's order, and certainly did not have the opportunity to respond to the company's rebuttal testimony. But as I said, I don't think it's relevant because this is an issue of essentially an incentive compensation in effect for highly compensated executives, where there is a benefit above and beyond the qualified plans. If there wasn't something above and beyond that, based upon the higher income levels, then there would be no CERP whatsoever. It's a plan that was created to bypass this particular limitation.
But you agree the same formula is used?
I agree with that.
Qualified and non-qualified.
I agree that that's what the commission order said, and that's what the company's rebuttal testimony said, but I don't have any personal knowledge of that, nor do I think it's relevant.
Hey, we turn to page 13 of your testimony now, Mr. Collins.
I'm there.
And starting about a third of the way down, you discuss cash working capital, do you not?
Yes, that's correct. That's something that the commission will need to address if it decides to proceed with rate base in lieu of capitalization as the approach to calculate the return on component of the revenue requirement.
And actually, you anticipated my question. If the commission decides to use capitalization, then this notion of cash working capital and lead lag studies, the commission would not need to address that. Would you agree?
Yes, that's correct. There are a series of other adjustments to capitalization that I propose if the commission does not decide to go forward with the rate base approach. But cash working capital is not one of those adjustments to capitalization that I have identified.
Thank you, Mr. Collins. Did the commission direct the company at any time prior to or during this case to perform a lead lag study and calculation in connection with the calculation of rate base for this case?
Not to my knowledge.
And if we could turn to pages 34 to 36 of
Okay.
And I believe you discussed this with Ms. Frederick of the commission.
The issue,
Income tax rates and expense.
yes, there were a couple of questions. Yes.
Okay. And at page 35 of your testimony, you recommend, quote, the commission treat Kentucky Power as a standalone entity for the calculation of state income tax. Is that correct?
Yes, in the same manner that it treats the company as a standalone entity for federal income tax purposes. For example, the commission has rejected the use of consolidated tax savings, instead finding that the federal income tax expense should be calculated on a standalone basis. The commission has rejected the use of an interest expense deduction from an upstream affiliate, including the parent company. The commission has even rejected a standalone, a parent company loss allocation that is required under the AEP intercompany tax agreement that's recognized in West Virginia for APCO, and has instead said, listen, we're going to compute income taxes on for federal income tax purposes as if Kentucky Power were a standalone entity. Given that there are none of these benefits from Kentucky Power's affiliation with AEP in the calculation of federal income tax expense, I think it's only appropriate and equitable that there not be any impact on the state income tax expense from factors outside of the state of Kentucky. It should be calculated on a standalone basis, just like the federal income tax.
So if you would agree then, if the blended state tax rate of 5.845% used by Kentucky Power was based on the company's standalone operations, that it would be appropriate to use?
I don't understand that question.
Well, you've indicated that Kentucky's state income tax rate that's applied should be should take into account or should be calculated as if Kentucky Power were a standalone company, right?
Yes, which would mean 5%, not 5.85%.
Do you disagree that Kentucky Power pays income tax to other states for its Kentucky Power operations? That's the basis of your testimony?
I've seen no evidence of that fact. These are apportioned state income tax rates from other states, and then the Kentucky state income tax rate is apportioned downward in the company's calculation. The company does not, to my knowledge, pay income tax expense in any of these other states. It's domiciled exclusively in Kentucky.
You agree that Kentucky Power has operations in West Virginia, the Mitchell plant?
Yeah, Kentucky Power has the two Mitchell units located in West Virginia, but its taxable income is not derived from West Virginia, its taxable income is reflected in Kentucky taxable income. In other words, Kentucky Power does not have a legal entity in the state of West Virginia whereby it pays West Virginia income tax expense.
And that's your belief, and that's the basis for your recommendation.
Well, there's no other evidence in the record to the contrary, and the company just simply apportioned these rates from other states and then blended those multiple state rates into the state income tax rate that it used in this rate filing.
One moment, Your Honor, I need to take a second to consult. Would that be okay?
That's fine.
I have no further questions, Your Honor.
Redirect, Mr. Kurtz.
Thank you, Chairman. The Vice Chairman was asking you about the pension and the OPEB rate base issue. Do you recall that?
Yes, I do.
You used the phrase highly unusual in describing this accounting treatment. What did you mean by that?
To my knowledge, and I have been in hundreds of utility rate proceedings, I believe that the AEP operating utilities, including Kentucky Power Company, are the only ones that employ this memorandum accounting where they use account 165, which is a prepayment account, and put a positive dollar amount in whenever they pay something into the pension or the OPEB trust funds, and then immediately, simultaneously, create a negative entry to take it right back out of the account 165 prepaid accounts. And the company itself has described this as memorandum accounting. In other words, it's not required by GAAP, it's not required by the FERC Uniform System of Accounts, and it isn't used, this accounting is not used by any other utility other than the AEP utilities to the best of my knowledge.
Also in that discussion with the Vice Chairman, you used the phrase misnomer. Do you recall that?
I did. The reason I use that term is because I don't believe there's anything that is prepaid. Just because the company used account 165 to create both a positive and an equivalent negative entry does not establish factually that the company has prepaid anything. And it's just simply a function of where the company is using or recording this memorandum series of entries. But because whatever positive amount is put into the account is then taken out with a negative amount, there is no prepayment. The prepayment, by definition, under the company's accounting is zero. And I cringe whenever I hear that term prepayment because it's not accurate.
So there's no actual cash outlay in your understanding?
Well, there is cash outlaid to fund the pension trust fund and the OPEB trust fund, but the question is whether or not those require a return on in rate base or that whether or not there's any prepayment. The company, without getting too far into the weeds, records its pension and OPEB trust fund assets on its balance sheet and also records the pension and OPEB liabilities on its balance sheet. And it is it's somewhat overfunded on one, the OPEB trust fund, and underfunded on the pension. And so the balance sheet has amounts in certain other accounts that show the funding status. But there is no amount in the prepaid when you consider the negative accounting entries that are made simultaneously with the positive accounting entries.
Turning returning to the capacity charge discussion with Mr. Overstreet, you referred to a provision of the settlement agreement that envisioned that the commission may disallow the $6.2 million for rate-making purposes. It was under the procedural terms, page 7 of the settlement agreement. Do you remember your reference to that?
Yes, I don't have it in front of me, but I can probably pull it up, or if, let's see.
Let me just ask you, is it your understanding that the settlement agreement envisioned that the commission would disallow the $6.2 million and that the company's remedy was to start proceedings to pull out or terminate the unit power agreement?
Yes, that's my recollection.
Well, why would the company not do that in today's world, do you know?
I don't know, quite frankly. But I will say this, that the company, according to the testimony of other witnesses, company witnesses in this proceeding, did not do anything to attempt to ensure that it was protected when the AEP and AEP Genco and Indiana and Michigan all decided that they would put a new SCR on Rockport Unit 2. The company just simply apparently accepted that. And go ahead, Mr. Kurtz.
Was the FTR part of the settlement of a consent decree with the EPA and the Sierra Club, as well as litigation brought by the owner of Rockport Unit 2, the Wilmington Bank and Trust Company?
First of all, AEP entered into a consent decree with the EPA and the U.S. Justice Department, not with respect specifically to Rockport, but with respect to all of its system-wide generating assets, but decided to put the new SCR on Rockport 2 to also address concerns and I believe litigation by the Wilmington Trust Bank and other lessors. So it basically achieved, its obligations under the consent decree with the U.S. Department of Justice, and also resolved litigation with the lessors. And Power did nothing, to my knowledge, to participate in that process or to protect the interests of Kentucky customers.
With respect to that SCR, the Attorney General KIUC position is that it should be recovered in rates in Kentucky, but because it's a 20 or 30-year asset, the recovery should be over 10 years rather than 3 years. Is that correct?
Yes, that's correct. Indiana and Michigan, in a recent rate case in Indiana, proposed a 10-year amortization of the SCR cost for its share of the Rockport 2 unit. And the commission in Indiana accepted that, and I think that, that was a reasonable proposal by Indiana and Michigan and Indiana, and one that this commission here could, I think it would be reasonable to reflect that same 10-year amortization for Kentucky customers.
And of course, Kentucky Power would be made whole because of the weighted average cost of capital carrying charge on deferral.
Yes, that's correct. The company's environmental surcharge allows the company to include the cost of the SCR in rate base for the calculation of the surcharge. And so if the amortization expense was less over the next couple of years, because there's only a couple of years left under the unit power agreement, it expires December 8, 2022, or actually December 7th, 2022. There's only about 2 more years to recover the remaining net book value of the SCR on Rockport 2. If that were extended to 10 years, then the the remaining net book value of the SCR as it's being depreciated would continue to be recovered in the environmental surcharge. So the company would absolutely be made whole.
On page 58 of your testimony, with respect to this capacity charge, you determined that when you add the 6.2 million amount of money to the 12.16% return on equity that is baked into the Rockport Unit Power Agreement, that the effective return on equity that AEP would receive, if you count the 6.2 million, would be 33.81% return on equity?
That's correct.
Did you have cause to calculate the net present value of the capacity charge payments that has been received by Kentucky Power over and above cost of service?
Yes, I did. I took the nominal dollar amounts and then escalated them to $2020 to reflect the payments that customers had made under this capacity cost rider. And the net present value of those payments is $173 million.
Without rendering a legal opinion, but is it your understanding that the commission has an independent obligation to assure that current rates are reasonable, regardless of what a settlement agreement between litigants may provide?
That is my understanding, and I would think intuitively that would be the case. And it appears as if the company might agree with that because it offered to terminate the $6.2 million, which would be a change in the terms of the settlement agreement.
Your Honor, I apologize. I tried to object to that question and answer in a timely fashion, but we had a technological problem. Record, please note my objection, and because Mr. Collin can't answer that question without rendering legal opinion.
Yeah, we've had probably too much of witnesses who testifying about what the law says somebody can and can't do. Unfortunately, this cat is already out of the bag, Mr. Overstreet, but you may continue, Mr. Cross. But I think we all understand what everybody's position is and what's going on here and how this worked out.
One last question on the state income tax issue. When you say that the state income tax was apportioned to Kentucky Power, what did you mean by that?
What the company did was it took the state income tax rates from all of the other AEP operating companies, operating utilities that is, and allocated a portion of that to Kentucky and reduced Kentucky from 100% to reflect the allocations from these other states. It isn't as if Kentucky pays the income tax in those other states, which is one of the reasons why I disagreed with that approach.
Last question. If Kentucky has the lowest state income tax and it's apportioned upward, does that mean the operating companies in other states that have higher income taxes are apportioned downward? In other words, get the benefit of Kentucky's lower corporate income tax?
Presumably that would be the case, but I have not reviewed what those other operating utilities do in those other states for rate-making purposes.
Thank you, Mr. Collin. No further questions, Your Honor.
Okay, thank you. Mr. Collin, you may step down. Thank you.
Okay, you're welcome.
Let's, I guess we've been going here for almost 2 hours. It's 15 minutes until 11 o'clock. Let's recess until 5 till 11. That's a 10-minute break, and then we'll come back and I guess you can call your next witness, Mr. Baudino. Is that correct?
Yes, Your Honor, Mr. Baudino will be next.
Okay, thank you. We'll be in recess until 5 minutes until 11 o'clock.
I don't think so, Your Honor.
Oh, Mr. West, are you going to, oh, you're the cross. I get this, you guys have been on the stand so long, I apologize. I like your
All right,
mask.
Your Honor.
You're kind of doubled up there, so you're protected.
I'm always ready, though.
Well, that's good. Mr. West, are you ready to present your next witness?
Yes, sir, we are. I see that the hearing room video is still paused. Is that how that's supposed to be?
Is everyone?
Oh, there we go. Okay, I see you now.
We're good now. We're good
Okay.
now.
Mr. Baldino, would you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, Mr. West?
Thank you, Your Honor. Can you please state your name for the record?
Yes, my name is Richard Baldino.
And what is your business address?
It's J. Kennedy and Associates, Inc., 570 Colonial Park Drive, Suite 305, Roswell, Georgia.
Okay, and what is your occupation?
I'm a consultant for J. Kennedy and Associates.
Did you cause direct testimony to be filed in this case?
I did.
Do you have any additions or corrections to that direct testimony?
I have 2 typos to correct, and that's on page 41 of my direct testimony. If you go to line 8, it says yes, table 5. That should be table 4. And then the label of the table 5 there, it says McKinsey ROE results. That should be table 4. And those are the only corrections I have.
Okay, thank you. Did you sponsor any responses to data requests in this case?
Yes.
If you were asked those same questions again today, would your answers be the same?
They would.
Is it your intention to adopt the direct written testimony as your testimony in this matter?
Yes.
Chairman, the witness is available for cross-examination.
Thank you, Mr. West. Ms. Frederick, cross-examination?
Thank you, Your Honor. Good morning, Mr. Baldino.
Good morning, Ms. Frederick.
Your analysis supported an ROE range of 8.93% to 9.25%. AMG recommended an ROE of 9%. Is that correct?
Yes, actually, just to be more precise about it, I recommended a range of 8.93 to 9.25. It was actually Mr. Collin who recommended the 9.0% for AG and for LUC, and he set forth the reasons for that recommendation in his testimony. Now, I do support that, given that that recommendation falls within my recommendation.
Thank you for that clarification. And you included high and low end results when calculating the average model return, is that correct?
Now, is that the DCF that you're referring to?
Yes.
Yes, my testimony and my exhibit show that I used just about all of the values with the exception of one, and I'm going to just refresh my memory here a bit. If we go to exhibit number RAB4, page 1 of 2, you see here I used averages for all the values with the exception of the growth rate that I used for Exelon. I substituted the Zacks growth rate for the Yahoo Finance growth rates for Exelon, which was negative. But other than that, I used all of the values. I averaged those growth rates and also presented the median value.
Thank you. And do you believe that including those results skews the model?
I don't believe that it does. I think that you have a large enough group here, 21 utilities, with a variety of growth rates there. And I think what we're looking at is what can a reasonable expectation be for growth for this proxy group of companies. So I presented the average and as one measure of sort of central tendency, if you will, or expectation for that group. I also
presented the median growth rates for each of the 4 sources that I used as another alternative view of central tendency. So I think using those two certainly is a reasonable, gives a reasonable confirmation that those, both the averages and the medians are indicative of investor expectations of growth for this group.
And can you explain briefly why you believe it's important to include those results?
Yes, and this is something that I disagreed with Mr. McKenzie about. You start picking and choosing results on the low end to throw out because you think they're too low, and then it calls into question why you didn't throw out the results that may be too high. And then you start arguing about what the standards should be for throwing out and including these numbers. So again, I think with the size of the sample and with the averages and the medians being used, that's indicative and that's reasonable to could just go ahead and include all of those numbers.
Okay, thank you. We're going to turn our attention to beta values for just a moment. And the market has recently seen an increase in utility beta values, is that correct?
Yes.
And do you know if betas for most investments made an upward or a downward adjustment, or is this just occurring in the utility sector?
I haven't made that.
I'm sorry, we cannot hear the witness. Ms. Frederick, can you hear us?
Yeah, so Chairman, I believe that Mr. Baudino may be participating by phone for his audio. Is that right, Mr. Baudino? Yeah, and he was caller 6, and I believe the IT staff may have just, in the middle of his response, muted caller 6. I don't know why I know that, but I just saw it, and it was simultaneous, so we'll see if that helps. Can you try again, Mr. Baudino?
Sure. Could you repeat the question, please?
Sure. We were discussing beta values, and I was asking you if betas for most investments were making an upward or a downward adjustment, or if that's just occurring in the utility sector.
Yeah, I haven't looked at all the different sectors. It certainly was the case for the utility sector. There was a lot of volatility for the entire market as a whole. So, of course, the beta value would have been calculated based on weekly price changes of each of the companies in this group versus the weekly price changes of the New York Stock Exchange Composite. That's how Value Line calculates those betas. And so, you know, the market was volatile also, and with apparently what happened from the time we saw the betas that Mr. McKenzie had filed in his direct testimony originally, and there was this huge increase in beta, and it was likely due to this pre-market volatility that we saw, you know, earlier this year, and so yes, that certainly did increase the utility beta substantially, apparently, or at least made contributed to that change. I was kind of surprised because the beta values are based on 5 years of historical price changes. So I was kind of surprised to see such a huge change within that sort of quarterly period.
And do you believe that this is a permanent adjustment or a reaction to the economic situation resulting from the pandemic?
Well, we'll see. I mean, I think
Okay, stop, could you stop? Mr. Baudino, I hate to interrupt, but I've gotten word here we needed to stop for some reason.
Yes, and I apologize, Ms. Frederick and Mr. Baudino. Can I please have everyone who's not speaking mute the line? We have some noise coming through, and it's interfering with our ability to hear the witness. I appreciate it. Perhaps Ms. Frederick
Okay.
should repeat the question.
Yeah. Ms. Frederick, could you repeat the question, please?
Sure, thank you so much. I was asking if you believe that this adjustment in betas is a reaction just to the economic situation resulting from the pandemic.
I think he contributed to it. And, we'll see if it's permanent or not, or if it will go back more towards the historical relationship where, beta the beta for the utility industry was significantly lower than it is now. And I think the sort of red flag on the beta here is to look at the results from of the CAPM just that Mr. McKenzie reported from his direct testimony to his rebuttal testimony. There's just a huge change in the results for the CAPM and the ECAPM in his testimony from direct to rebuttal. So we will see what investors expect. I would kind of agree with what Mr. McKenzie said, which is we can't really know what the beta is in investors' minds. We can estimate it using historical betas, which he and I both have done. Whether the currently high betas recede to more historical levels as they were earlier this year and last year, we will just have to see.
Thank you for that. And one last question on betas. There's recently been an uptick in the number of COVID-19 cases, and states are again imposing restrictions. Do you believe that betas will once again move, and if so, in what direction?
Well, that I don't know. I mean, this is certainly an unusual time in the world and in the United States right now. We're kind of in uncharted waters. So, quite honestly, I don't have an expectation there one way or the other. We'll just have to see how it plays out.
Thank you very much. Your Honor, I have no further questions for this witness.
Ms. Grunman, questions for Walmart?
No questions for this witness, Your Honor.
Mr. Spinard?
No questions, Mr. Chairman.
Mr. Fitzgerald?
No questions, Mr. Chairman. Thank you.
Mr. Miller?
Thank you, Mr. Chairman. No questions.
Mr. Fry?
No questions, Mr. Chairman.
Vice Chairman Chandler?
Yeah, just a few. Thank you, Chairman. Good morning, Mr. Baudino.
Morning.
Were you able to watch the portion of the hearing in which I cross-examined or asked questions of Mr. McKenzie?
Yes.
Okay. And do you remember me asking questions about his reference and his direct testimony to the HOPE standard, and some of the language that's used in HOPE, that the Supreme Court used in HOPE?
Yes, I was there for that.
Okay, and I just want to ask you, I guess, the same basic line of questioning. Insofar as HOPE discusses under a just and reasonable standard, the rate-making process requires a balancing of investor and consumer interest, or ratepayer interests. Did your testimony necessarily take that balance into consideration, or did your recommendation focus exclusively on the investor interests?
I would say, Vice Chair Chandler, that my analysis is really more towards what are investors requiring in the marketplace for a low-risk electric utility like Kentucky Power. So, in that sense, I pretty much focused on the investor side, and also on the market side. What is the market requiring right now for ROE for a utility like Kentucky Power? So I didn't focus on, say, the ratepayer side necessarily. I figure if the company's allowed to earn a market-based rate of return, that sort of satisfies the balancing of interests.
Okay, so I guess I understood the response until the final part of it. So I would ask, insofar as the commission has to balance the two, and is required to balance the two. Does your recommendation, in your opinion, balance the two, or is it your position that the commission should balance it, and that you've given the investor piece of it?
Let me answer it this way. Normally, I just look at the investor piece of it. However, I also support Mr. Collins' recommendation of 9.0%. And in that recommendation, Mr. Collins in his testimony does take into account some of these other factors. And, we have essentially followed the same path as the company in terms of rate mitigation, going down from the top end of my range, which is 9.25%, down to 9%, as part of rate mitigation, which would mitigate rates for the sort of economically distressed area in which Kentucky Power serves. So I formed the sort of the range that Mr. Collins used. He recommended 9%, and I support that, by the way, as being within my range.
So is it fair to say that insofar as you and Mr. Collins balanced or intended to balance the consumer and the investor interests, it's merely a reflection of the revenue requirement reduction from the lower ROE you proposed than as the company proposed? Is that a fair? Okay.
Sorry. Yes.
Okay. All right. I appreciate it, Mr. Brodino. Thank you.
Dr. Matthews, questions?
I do not have any.
Mr. Garcia, cross-examination.
Thank you, Elmer. Good morning, Mr. Brodino. Can you hear me?
Good morning, Mr. Yes, I can hear you fine.
Yeah, I'll try to go slowly. It's not only that I have an accent, but with the technology, I hope that we can communicate without having periods where the court reporter cannot take it. But just to let you know, if there is something that you cannot hear, it may be helpful for you to let us know, maybe with a signal of the hand or something. Is that okay?
Okay, sure.
And I am going to try to simplify my life a little bit. If I refer to the Federal Reserve as the Fed, you will know what I'm referring to?
Yeah.
Okay, I'll try not to do it, but I have a tendency to. Would you please turn to page 4 of your testimony?
I have that.
There in line 7, and actually in your testimony this morning already, you referred to Kentucky Power as a low-risk regulated utility?
That's right.
It's Kentucky Power's Moody's credit rating Baa3?
Yes, it is. And its S&P credit rating is A-.
Yeah, Moody's rates Kentucky Power on a standalone basis, is that correct?
Yes, that's right.
And just for the record, obviously it may be Baa3, it's a lower credit rating than, for example, Baa1?
Well, it's 2 notches lower, but it's still within that Baa rating. And it's still an investment grade.
And Baa1 is lower than A3?
Baa1 is higher than Baa3.
No, I'm sorry. Baa1 is lower than A3.
Yes, it is.
Okay, and A3 is lower than A2?
Yes.
Okay. Investors require a higher return for a higher investment, higher risk investment, correct?
That's generally correct, yes.
Would you agree that from an investor's point of view, a higher credit rating implies a lower investment risk?
Lower investment risk, did you say?
Yes. The higher the credit rating, the lower the investment risk.
That's generally correct. I'd agree with that.
And the converse is also true. The lower credit rating implies a higher investment risk, correct?
Yeah, that's right.
Okay. Do you recall Moody's credit rating for Duke Energy Kentucky?
That was a Baa1.
Okay. And for Kentucky Utilities?
Now, I believe that was contained in the company's confidential hearing exhibits. And subject to check, I believe that was A3.
And for Louisville Gas and Electric?
I believe that's A3 as well.
Okay. Your Honor, in order to keep things smooth, I may be able to enter into the record exhibits 4, 5, and 6, company hearing exhibit 4, 5, and 6, which are each of the 3 is confidential, without showing them on the screen. So it's possible that we may not need to go to confidential session if I can try.
Okay, yeah, we can do that. I mean, let me ask counsel. He wants to show it on the screen without going into confidential session or not?
No, Your Honor, I'm sorry, if I may. I don't want to show them on the screen. I think that I can ask the necessary questions to enter into the record.
Okay, but you want to introduce those exhibits at some point into the record, but we'll have to do
Correct.
that into the confidential record. Okay. All right.
Correct. Mr. Baudino, you made reference to the confidential hearing exhibits of the company. Are you familiar with the documents that have been identified as confidential hearing exhibit 4? Let me ask you one by one. Are you familiar with that document?
Well, let me just make sure that we're on it. Yeah, that's all right. I'm just going to, I have these on my laptop here, and I just want to make sure we're referring to the same thing. So did you say number 4, confidential number 4?
Yes.
Okay. And that would be Duke Energy Kentucky, Moody's credit opinion?
That is correct. And that information, it's not confidential. I mean, that's what it is.
Okay.
So you're familiar with that document? You recognize it?
Yes. Yes, I
Okay.
do.
And let me ask you the same question for confidential company hearing exhibit, confidential exhibit number 5.
Okay. I have that.
Okay, and what is that? Without describing its content.
Sure. It's the Moody's credit opinion for Kentucky Utilities Company, and that is dated October 23rd, 2020.
Okay, and you are familiar with that document?
I haven't made a detailed review of it. I did review the first couple of pages of it just to generally familiarize myself with it.
Okay, and then the same line of questions for company confidential hearing exhibit number 6.
Okay, I have that one.
Okay, and can you identify what the document is for the record without describing its contents and whether you're familiar with it?
Sure. Again, this is Moody's credit opinion for Louisville Gas and Electric Company, and that is dated October 23rd, 2020.
Your Honor, at this point, I would like to move for the admission of those 3 documents that have been identified into the confidential record.
All right, sustained, let them be filed as what, 4, 5, and 6?
Yes, Your Honor, confidential exhibits 4, 5, and 6. Thank you. May I proceed?
Yes, you may.
Okay. And I'm not going to need to go into confidential session now that we have done that. So, Mr. Badino, let me turn your attention to page 10 of your testimony, please.
Okay, I'm there.
And in your testimony, you make reference to the Federal Reserve's reaction to the economic effects of the COVID-19 pandemic in March of 2020.
That's right.
If I understand correctly, the Federal Reserve lowered interest rates in March of 2020 in order to stimulate the U.S. economy.
Right. Yeah.
Okay. Do I understand correctly that in 2019, prior to the coronavirus pandemic, there were disturbances to financial markets in the United States associated with internal trade tensions involving the United States?
I haven't looked at that. I'm not sure exactly what you're talking about, or what you're referring to in your question.
Let me try to establish it in bits. Are you aware that in 2019 there were disturbances to financial markets associated with trade tensions involving the United States?
Yes.
Is your understanding that in 2019 the Fed lowered federal fund rates 3 times?
Yes.
Is your understanding that lowering of interest rates by the Fed in 2019 was related to the financial market disturbances that resulted from international trade tensions involving the United States?
Well, I did cite that in my testimony. Fed lowered interest rates, its federal funds rate 3 times in 2019, and I think that was a contributing factor you mentioned.
Are you also aware that in 2018 there were increases to interest rates by the Federal Reserve?
Yes.
Now, let's turn back to March of 2020. The Federal Reserve's reaction to the COVID-19 financial crisis was a significantly greater scale than the interest rate management of the Fed during 2018 and 2019. Would you agree?
Oh, absolutely, yes.
I'm sorry, Mr. Badino, would you repeat that answer?
Yes, I said that absolutely, yes, I would agree with that.
Okay. Would you agree that one of the levers that the Federal Reserve pulled, to use a metaphor, starting March of 2020, in addition to lowering interest rates, was to increase its holding of Treasury securities?
Yes, and it increased it substantially.
Thank you, sir. And actually, you described it as substantially. Would you say that the current Federal Reserve holding of Treasury securities is at an unprecedented level?
Yes, it's an all-time high.
In fact, would you agree that it's about double of the holdings that the Federal Reserve had even at the highest point of the Federal Reserve's reaction to the 2008 financial crisis?
No, I haven't made that calculation. I would say it's substantially higher, though. Yes.
Okay. Mr. Badino, would you please explain what the VIX index is?
That is the volatility index, and I explained this beginning on page 12 of my testimony, and that is an index that the Chicago Board of Options Exchange uses to sort of gauge the market expectations for price volatility over the next 30-day period. and that's a formula CBOE uses. And it's, like I said, it's sort of called the fear gauge or the fear index.
Thank you. In March of 2020, the VIX, I will just refer to it as the VIX, as the VIX. In March of 2020, the VIX had its highest spike since the 2008 Great Recession. Is that correct?
I'm not sure if that was a high spike since then, but it certainly spiked up, as it was said here on page 13. It shot up to a high of 82.69 on March 16th. And obviously that's a huge spike. As I said further on in my testimony, page 6, line 6 and 7, you compare that to the daily average VIX for 2019 is 15.39. So that gives you some order of magnitude about how large that spike was.
You indicate also in your testimony around page 13 that since March 2020, since that spike that you just described, the VIX has gone down somewhat but remains at an elevated level, correct?
That's right. That it's elevated. Let's see. I had the number.
We're going to a hearing this morning in Frankfurt, and definitely was on a computer listening to it while I was in here. But now she's going to come in here, so we take the computer.
Hey, Mr. Childers.
It's very boring.
Mr. Childers.
So this is about a waiver of formal settlement. So this means.
Mr. Childers? Mr. Childers, please mute your computer. We can hear the conversation.
Okay.
Thank you, Honor. May I proceed?
Yes.
Thank you, Honor. Mr. Baudino, let's have this a little bit comparative. For these elevated levels of the VIX that we are talking about, would you agree that the current level is more than double than the approximate 11-point VIX average level in 2017?
Yes, I'd agree to that.
Okay. In your testimony, you had a level of 26.38 as of September of 2020?
That's right.
Okay. Are you aware that in late October, the VIX went over 40 points again, another very high spike?
I mean, I would accept that subject to check. Yeah, you know, I don't have that data in front of me. I did check the VIX a day or two ago, and it was about 22.
That I understand. And just for the record, and since you said that you checked there a couple days ago, last Friday, as of close of November 20 of 2020, it was above 23 points. If you know.
That sounds about right. I would accept that subject to check.
Would you agree that during times of higher volatility, the risk that investors perceive and face is greater than at times when volatility is lower?
Other things being equal, yes, I would agree to that.
Would you predict that the VIX will remain around 20 index points over the next 2 years?
I don't have the basis for that prediction.
Right. You would agree with me that nobody could predict, for example, if over the next 2 years, the VIX is going to remain at, say, the 11 index points that were the average in 2017, correct?
I don't have a basis for a prediction for the VIX for the next couple of years. We do know that it was, I would accept your 2017 number as 11. It has gone up, in 2019 it was higher than that, 15.39, and we expect it to be elevated. I would expect it to be elevated from that level this year, for the rest of this year.
Okay, let me ask you something, and let me zero in on what I was asking you. Nobody can predict the VIX for the next 2 years, correct?
I don't think anyone could predict it with any level of assurance or accuracy.
Thank you. Let me ask you this. Hypothetically, if the VIX were to remain at a stable level, say at 11 index points, or even at 20 index points over an extended period of time, would you expect that at the same time the betas for electric utilities would tend to move back lower to historical levels? In other words, are these two measures somewhat related?
Well, the VIX measures volatility as a whole, and with respect to, the volatility of utilities, of regulated utilities, one thing we do know is that their price stability is greater than the market as a whole. So, if historical relationships were to continue with that, I would expect the prices of regulated utility companies to be lower in terms of price stability than the overall market.
Right, and I was asking you specifically about the betas for electric utilities. If the market at a period of stability as reflected by lower level VIX, you would expect that the betas would tend to go down, correct?
They might. That would be a reasonable guess. But again, we will just have to see what happens. I think the market will show us what happens in the future with regard to that.
Definitely, thank you. Mr. Baldino, would you turn to page 14 of your testimony again, please?
Okay, I have that.
Are you aware that a significant portion of Kentucky Power's load is commercial and industrial?
Yes.
Is the fact that a significant portion of Kentucky Power's load is commercial and industrial a risk factor for Kentucky Power's opportunity to earn its authorized ROE?
It tends to elevate the perceived risks as far as the credit rating agencies are concerned. Both Standard & Poor's and Moody's did mention that.
Okay, and from the point of view of an equity investor, the risk of Kentucky Power having more of its load be commercial and industrial tends to increase the risk factor of investment in Kentucky Power as well. Is that true?
Well, if the other things being held equal, yes. But of course, these credit analyses and credit opinions take in a variety of these risk factors, as well as credit strength. So you can't really just isolate on one particular factor.
Understood. But other things being equal, just like you indicated, it would be the case that the concentration of Kentucky Power's customers' load in commercial and industrial customers tends to increase the risk of Kentucky Power, correct?
Well, according to S&P and Moody's, yes.
Would you agree that Kentucky Power is not one of some companies for which the problems associated with that concentration and with COVID-19 weren't as severe as originally feared? And I'm paraphrasing the words from your testimony on the top of page 14.
Okay, I read that, and would you mind repeating your question, because I'm not sure I quite followed it.
Certainly. Would you agree that Kentucky Power is not one of the companies that are described in your testimony as some companies for which the problems weren't as severe as originally feared?
Well, yes, I would agree that Kentucky Power is not necessarily included in that. This was go back on page 13. This was from a Value Line report on the electric utility central industry, and it was just sort of reporting on companies in that particular area, and was making a more general statement. It didn't necessarily include or exclude Kentucky Power.
Your Honor, at this point I would request to impose on staff to show hearing exhibit, company hearing exhibit 10.
Thank you, Mr. Garcia.
I may be able to.
Kentucky Power Hearing Exhibit 10.
And hopefully I may be able to shortcut some of the questions that I had based on the answer that Mr. Baldino just provided.
Sometimes it takes just a moment to be able to pull that up.
Thank you.
We have one slight issue. I will resolve it.
Understood. And I actually kind of ask a few questions and probably make it even shorter this way. Mr. Baldino, on page 14 of your testimony, you make reference to regulatory proceedings associated with the coronavirus. Is that correct?
On page 14?
Correct.
Are you referring to lines 5 through 8?
I am.
Okay, yes, that was an excerpt from the from the Value Line report that we were just discussing.
Understood. Are you familiar with the Commission's docket, case number 2020-00085, which is the Commission's docket regarding COVID-19?
I'm not familiar with that.
Okay. But are you familiar that the Commission has a COVID-19 docket?
Yeah.
And what's being shown right now, it's publicly available data response in that docket. The questions that I'm going to ask you do not require that you actually know the underlying information, but I'm just going to ask you about the effects, and if you want to take the data, just as a hypothetical, that may help us speed this up. Would you agree that from a credit metrics point of view, it is negative for the company to have nearly double the bad debt expense level that as compared to the level authorized in base rate in the last case? As a general proposition, you would agree that that's negative from a credit metrics point of view, correct?
I'm not sure, I'm not really sure if I would agree that that would be a negative from a credit metrics point of view. It would depend on what the commission's treatment ultimately of that bad debt expense is.
I understand. Let me ask you about a particular credit metric called FFO to debt ratio. You're familiar with that metric?
Yes.
Okay. Would you agree that other things being equal, bad debt expense of $1.6 million in excess of bad debt expense level currently reflected in rates would erode Kentucky Power's FFO to debt ratio?
Well, it may erode its current FFO to debt ratio. However, we're in a rate case now, and the commission and company presumably would be, have ways of treating that bad debt expense, and that would, impact future FFO to debt ratios. And I don't know how that particular issue is going to be resolved. That's really not my issue.
Understood. Actually, that may then mean that I should move on to a different topic. Let me ask you this. Would you agree that other factors being the same, poor credit metrics, and an increase in bad debt expense would increase the investment risk of Kentucky Power?
Well, no. And the reason is because we're in the midst of a rate case now, and really the credit rating agencies are going to look at, what comes out of this case as to if the credit supportiveness, and as far as we're concerned, we're getting back to bad debt expense, not my issue. Mr. Collin is the one who addresses the company's revenue requirement. I can say, in general, out of this case, the KIUC and AG position is credit supportive for the company. We're recommending a roughly $43 million base rate increase, and that credit supportive the company's current revenue levels. As I said, we're recommending a rate increase that is credit supportive. We're recommending an ROE, an allowed ROE, that is significantly greater than the company's earned ROE a couple of years. So again, I don't think you can necessarily take out one issue like that debt expense and say that because it's currently high, that it's credit negative. The resolution of that will be part of the company's credit going forward, and Moody's and S&P will be making their own decisions based on whatever the commission decides in this case going forward. But I can say generally our position is credit supportive, and how Moody's and S&P will deal with that, will deal with the commission order, is up to them, and I don't want to speculate on it. I can't speculate on that. That would not be a responsible thing to do.
I understand. So let me see if I can try to summarize and refocus what you just told me. There is a risk for investors that Kentucky Power will not be able to earn its authorized return even after this case, correct?
There's always that risk, and there's also the eventuality that if the company prudently manages its operations, that the company will earn its authorized ROE coming out of this case. What we have to do, and my understanding of what the commission does, is give the company the opportunity to earn a fair rate of return on its investment.
Right, but just to get back to the point, there's no guarantee that Kentucky Power will earn its authorized return, and that's a risk for investors, correct?
Well, in regulation, there's only the best the commission can do and the best any of us can do is provide an opportunity for the company to earn that allowed ROE. And as far as a guarantee, no, there's not an absolute guarantee the company is going to earn that. That's going to be based on economic conditions. It's going to be based a lot on the company's management of its operation. It's going to be dependent on what happens within the company's service territory.
Hey, Mr.
Also with this
Bodine, the reporter cannot understand your answer, so you need to start over. I'm sorry. Wait just a second. You have until what?
That's going to be based on economic.
She has it until the part of the sentence when you say, based upon economics. After that, we don't have anything in the record. So I don't know if you.
Okay.
Chairman?
All right.
Wait.
I've been asked to double check on something. Mr. Bodino, this is Ms. Vinsel. I wanted to make sure, are you using only your computer's audio, or are you using a computer and a phone?
I'm using a computer and a phone, and my audio is muted, and so is my computer audio is muted, so is my computer volume.
And you came through loud and clear at that time. We're just having some issues on echoes, and we're trying to track down where it's originating. Thank you.
Okay.
Okay, if you could, to the best you can, go back to a couple of sentences or something, 2 or 3 or 4, and try to complete your answer.
Okay. Let's see. I guess I was making. I hear some feedback.
Well, it's unfortunate, but apparently people, I don't know who they are, whether witnesses, lawyers, or somebody, they call in and they don't mute, and then as a result, the court reporter can't hear, and we have an issue with the records, and sometimes it's difficult for others to hear. But
Okay.
all we can do is try, and then of course we have these other issues too. We've had technological problems here that have been part of the issues, over the last 6 days too. Miss Vinsel has gone back to see if she can find staff and help resolve this issue. So if we can bear with her for just a second, we'll see what can be done, if anything.
Okay. All right.
If it's helpful, I can read back the portion of the answer that I took down.
Okay, what now?
If it's helpful, I can read back the portion of the
Okay,
answer.
all right, I will do that. Ms. Vinsel, what have we found?
We're going to try something a little different. We've tried muting part of this room to see, because it appears that all of the participants who need to be muted are muted. So we're going to try another workaround.
Are we ready to proceed or not?
We are ready to
Okay,
proceed.
now, Mr. Bodino and Mr. Garcia, the court reporter, can, if you can hear her, she can tell you what she last was able to understand and to put down in shorthand or whatever or type from what you said. Can you please repeat for Mr. Bodino and Mr. Garcia where you were last able to understand the answer?
Can you hear me?
Mr. Bodino, can you hear her?
Oh,
Yeah.
that will not work.
You can hear me now?
Probably not. One moment. Jim, can you go ahead and unmute the hearing room? Mr. Bodino, can you hear me?
Yes, I can.
Okay, thank you.
I'm gonna read back the question and the portion of the answer
All
then.
right.
Question, right, just to get back to the point, there's no guarantee that Kentucky Power will earn its authorized return, and that's a risk for investors, correct? Answer, well, in regulation, there's only the best the commission can do, and the best any of us can do is provide an opportunity for the company to earn that allowed ROE. And as far as the guarantee, no, there's not an absolute guarantee that the company is going to earn that. That's going to be based on economic.
Did you hear that, Mr. Baldino?
I heard some of it, and I think maybe it would be helpful if Mr. Garcia could ask his question again, and then I'll answer it again. Maybe that would be helpful.
I can certainly do that, Your Honor, and just to synthesize the point. Mr. Baldino, would you agree that other things being equal, there is a risk inherent for investors in the fact that Kentucky Power is not guaranteed to earn its authorized rate of return?
Yes, here's how I can answer that one. That is a risk that I would say all utilities face, that in that there's no absolute ironclad guarantee the utilities will earn their authorized rate of return. There's a lot of different factors that can cause under-earning, over-earning for utilities. So is that a risk? Well, it's kind of a generalized risk for the sector, I would say, not just Kentucky Power.
Your Honor, I only have like 2 or 3 more questions. I just want to make sure that we are good to proceed, or do we need to troubleshoot some more?
Well,
What did he say?
he wanted to know if we can proceed or if we were good to go. And we're not having the sound issues right now.
Oh, yeah, well, apparently the sound issues are all right, so if you have more questions.
Just a very few, Your Honor. Thank you. Mr. Baldino, in light of what you just told me, let me ask you this. Other things being equal, would you agree that it's bad for customers if over an extended period of time the company earns an actual ROE that continues to be much lower than its authorized ROE?
Did you say it's not the customer for that?
I'm sorry, I'm having difficulty hearing you, so I don't know what you need me to clarify from the question. I can ask it again.
Okay. Sure, please.
Yeah. Would you agree with me that other things being equal, it's bad for customers if over an extended period of time, the company earns an actual ROE that continues to be much lower than its authorized ROE?
Well, it's bad for customers and it's bad for the utility as well. In that, there's really not enough information to go on in that hypothetical question. However, I would ask why the utility has continued to, in that particular case, under-earn its authorized ROE over this long period of time. So if we apply this now to Kentucky Power, historically, since the last rate case, since the stipulation and the order from the commission in the last rate case, the company's under-earned its authorized ROE. And now we have the rate case and a chance for a reset to go forward and have the company once again try to earn its authorized ROE. I mean, that's what we're trying to achieve in this case. One of the things we're trying to achieve is a fair chance for the company to earn its authorized ROE. And generally speaking, I would say that's what the AGKIUC case is doing.
Just to clarify, I feel that you said it at the beginning, and I just want to make sure that the record is clear. So you would agree with me that it's bad for customers and bad for the company if for an extended period of time, Kentucky Power is not able to earn its authorized ROE, correct? Just to keep it simple. It's bad for customers and bad for the company.
Yes, that's right. And if that kind of situation occurred over a long period of time, I think maybe that's something the commission ought to investigate and find out what's responsible, because really, for regulatory purposes and for revenue requirement purposes, the company should be allowed a reasonable level of expenses and reasonable level of rate base to provide service to its customers. And if that's not happening over a period of time or period of years, then rate cases are one way to correct that, and that's what we're here for now.
General, if I can have a second.
Sure.
Unmuted.
Thank you, Mr. Baldino, and thank you, Your Honor. Those are the questions that I had on cross-examination.
Thank you.
Thank you.
Mr. West, to redirect.
Yes, just briefly, Your Honor. Mr. Baldino, just to reiterate, what was KIUC AG's recommended ROE in this case?
Our recommended ROE is 9.0%, based on my recommended range of 8.93 to 9.25.
Okay. And as you just indicated, that was based on your analysis, correct?
Yes.
Okay. Has anything that you've heard over the course of this hearing impacted that recommendation to either raise it or lower it?
No, in fact, really, after reading Mr. McKenzie's rebuttal and after listening to the hearing so far, nothing's changed my recommendation. I feel just as confident as I did when I filed my direct testimony.
All right. Thank you, Mr. Baldino. I have no further questions.
Okay, thank you. All right, it's noon, so at this point, we'll take a lunch recess until 1 o'clock, at which time I guess we will have Mr. Barron. Is that correct, Mr. West?
Yes, Mr. Barron will be our final witness. Thank you.
Mr. Baldino, you may be excused. Thank you very much. All right.
Thank you.
Hearing will be in recess until 1 p.m. All right, is everybody back? Mr. Kurtz, are you going to call the next witness for KIUC and the AG? Mr. Kurtz, can you hear? No?
Oh,
Now I can. Yes, thank you, sir. We call Stephen Barron.
Okay. Mr. Barron, would you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay. Mr. Kurtz, you may ask.
Thanks, sir. Will you state your name and business address for the record?
Yes, Stephen J. Barron, and my business address is J. Kennedy and Associates, Inc., 570 Colonial Park Drive, Suite 305, Roswell, Georgia, 30075.
Did you submit direct testimony, exhibits, and responses to data requests in this case?
Yes, I did.
And also on November 12th, did you submit in the record, or we submitted it for you, updates to some of your exhibits?
Yes, I did.
Can you explain what those were, please?
The updates, the updates consist of incorporating 2021 information that AEP filed under their OATT for transmission revenue requirements.
Okay, you've updated figure 1 in your testimony to include
That's
that?
correct. Yes, I updated figure 1 and some of a couple of the numbers, which I can go through, and table 3.
Will you go through the numbers, please?
Yes. The updates are to references on pages 16, 17, and 18 of my testimony. On page 16, I updated figure 1 to add the year 2021 to the chart. On page 17, I updated the value on line 3, the 19 million, to 28 million for 2021. So the 19 million is still correct for the year 2020, but the updated value for 2021 is 28 million. At the end of that line 3, the 25% for 2021 is 33%. And then on line 13, the reference again to 19 million would be 28 million. On page 18, I updated the results of table 3, and the values would be on line 8, the 14% value would be changed to 15%, and on line 10, the value 0.45% would be changed to 2.75%. And those are the updated changes.
With those changes, do you adopt this testimony?
Yes, I do.
And Chairman, I tend to the witness for cross-examination.
Mr. Chandler would probably like an errata sheet when you can provide one. There were several changes. You could be willing to do that? Okay, Mr. Kurtz.
Sorry, can you hear me, Mr. Chairman?
Yes.
Yeah, so I was checking it when they were going off. I think that everything the changes, the updates they've made have been filed. I was just looking at that. So.
Okay.
Thank you.
All right, Ms. Frederick, cross-examination.
Thank you, Your Honor. Good afternoon, Mr. Barron.
Good afternoon.
I just have one question for you this afternoon. Have you reviewed Mr. Vaughn's revised NMS2 calculations? And do you still believe that Mr. Vaughn's revised calculations are reasonable?
Yes, I do. I have reviewed it, and I believe it's reasonable, the changes that he made, consistent with my direct testimony.
Thank you very much. I have no further questions, Your Honor.
Ms. Grunman, questions?
No questions for this witness, Your Honor.
Mr. Spinard?
No questions, Mr. Chairman.
Mr. Fitzgerald?
No question, Mr. Chairman, thank you.
Mr. Miller?
None, Mr. Chairman. Thanks very much.
Mr. Fry?
No questions, Mr. Chairman. Thank you.
Vice Chairman Chandler?
Yeah, thanks, Chairman. Good afternoon, Mr. Barron.
Good afternoon.
I think I'll have very little for you, so congratulations. The question I want to ask is you provided in your testimony a $19 million sum in regards to the difference between, I think it was the Kentucky revenue requirement for transmission versus what Kentucky Power customers are paying pursuant to their allocation under under not only the transmission agreement but also the OAT for the transcos. Is that a fair characterization?
Yes, and I based that analysis on the reported transmission revenue requirements. So, but yes, that is correct.
And what I want to clarify is that the difference between Kentucky Power Operating Company's transmission revenue requirement and the amount that's the test year amount of OAT LSE expense, or is it the operating company amount plus the AEP Kentucky Transmission Company revenue requirement combined, and the difference of those two amounts versus what the company's paying on their LSE OAT expense for the test year?
It's the latter. And so for all of the companies, including the value for AEP LSE, which is I use to allocate sort of the base case, it includes both for each operating company, and in particular Kentucky, it includes the individual operating company revenue requirements and the corresponding state transco for that company, or associated relative to the geography of that company.
Okay, so the difference when you followed your direct is 19 million. Did that include the October filing for the transmission revenue requirements for either if Kentucky Power Operating Company filed theirs, but at least the 2021 cost for the Kentucky Transco?
The 19 million did not. It reflected the 2020 projected data. And so this update that I just went through with Mr. Kurtz was the corresponding analysis using for 2021.
Okay,
so that's why it increased to 28 million.
Okay, and that's what I want to make sure that we have. So the information provided. Okay, that's fair. So the difference between the revenue requirement amount for Kentucky Power Company plus the revenue requirement for AEP Kentucky Transco, both of those for transmission costs, is $28 million lower than the amount that will be allocated of LSE OAT expense under the different PJM and FERC tariffs?
Yes, that was the basis for the calculation. There, and it's based on an assumption. All of the assumptions that are used in the transmission agreement, basically a 12 coincident peak allocation. So I basically took the revenue requirements as reported for each year, including 2021, and then I adjusted those for the affiliate allocations, the non-affiliate allocations. Okay. So I removed that and then allocated the total on 12CP and compared that to the individual operating company values.
And just so that I'm clear, when you allocated on a 12CP, did you allocate it on the most recent 12CP calculation?
I used for the 12 CP, I used the values that I had used for 2020. So I did not update that, but I believe that it's the reasonable expectation is that it's going to be very, very close.
So the assumption is that whatever the 12 CP allocation of the AEP bill was this last time around, that you just applied that amount to the revenue requirement, or to the bill effectively that you expect AEP to get for transmission costs next year. Is that fair?
Correct, yes. It's roughly the 5.7% that we've been talking, that has been talked about in the case thus far.
Okay, all right, and there would be, that's I guess an estimate because we don't know what the 1 CP and 12 CP will be the next year. Is that again fair?
That's correct, and I think that relative to the dollars that we're talking about in terms of the dollar differences between an allocation of the entire AEP East share versus the standalone calculation, I don't believe that the slight differences in allocation factor would be material in terms of the dollars.
So the only update from the change in 19 million to 28 million is the update in the FERC filed revenue requirements.
That is correct, and it's primarily, as we had seen, the I&M investment and I believe Ohio Power as well, but in particular I&M. Yes, Ohio Power as well, or the Ohio region as well.
Right, between the Transco and the operating company.
Correct, and most of it is the Transcos.
Okay, all right, that's all the questions I have. Thank you, Mr. Barron.
Thank you.
Dr. Matthews, questions?
I don't have any.
Okay. Redirect, Ms. Glass?
Cross-examination, Your Honor?
Cross-examination, I'm sorry.
That's all right. Yes, I have just a few questions. Mr. Barron, can you hear me all right?
I can, yes.
Okay, could I please have staff put up on the screen a document filed in the record as in connection with the AG and KIUC supplemental update to Mr. Barron's testimony. It was filed on November 12, 2020, and it's titled Figure 1, Table 3, 2021 Update, Supporting Data.
One moment. Ariel, did you get that?
That's it. Thank you. Can you see this document, Mr. Barron?
Yes, and I have the original in front of me as well.
Okay, great. Did you prepare this document?
I did.
And this document reflects the underlying data that you used to prepare Figure 1 and Table 3 in your direct testimony, correct?
That's correct. As well as the addition of 2021.
Yes, okay, thank you. And I want to draw your attention to the highlighted figure in the top right of the document. It reads 2.276 billion. Do you see that?
Yes.
And this number represents your calculation of the AEP projected transmission revenue requirement for 2021, correct?
Yes, I mean, it comes directly from the OATT filings that the company puts on its website. But yes, it's a summation of the individual operating company and Transco's revenue requirements.
Okay, thank you. And just as a side matter, do you know what I'm referring to when I refer to RTEP, Regional Transmission Expansion Plan projects?
I do.
Okay, so in that highlighted number that I just pointed out, that highlighted number includes in it the revenue requirement for RTEP projects built by AEP, correct?
That is correct, and the individual company values include the RTEP amounts as well.
Okay.
So does that number include the revenue requirement for RTEP projects only built by AEP?
That's correct.
Okay, and does it include 100% of the costs for RTEP projects that only AEP built?
Yes, I had to make an assumption in this analysis as to whether I would use the total investment that included, or the total revenue requirements that included RTEP, some of which admittedly is going to be allocated outside the AEP zone, or the net that excluded the RTEP. And for this purpose, the assumption I made was to include, or the analysis was to include the RTEP values. And that is how I got calculated the 28 million. I also actually did the analysis for 2021 without excluding RTEP, where none of it was included. And in that case, the 28 million would drop to about 23 million. So it's still a significant difference. In other words, that's the amount that Kentucky standalone versus allocated under the transmission agreement. That's the difference. That's the additional, that's the so-called subsidy, even without any RTEP expenditures at all. Some of those RTEP amounts would, are probably the predominant amount of it would probably stay in the zone anyway.
Okay, and so does that number include the cost for any RTEP projects built by other transmission owners, not AEP?
No, it does not. And of course, the assumption is that those costs, let's say, for example, that Kentucky Power were its, excuse me, let's say Kentucky Power were its own zone. In that case, it would get allocated a share based on the formula in the OATT, Schedule 12. It would get allocated a share of other RTEP costs that are being socialized, 50% on load responsibility, 50% on DFACs.
Okay, thank you. That is all the questions that I have.
Mr. Kurtz, redirect.
Mr. Chairman, no redirect, please.
Thank you, Mr. Barron. You may step down and you're excused.
Thank you, Mr. Chairman.
Okay, now for Walmart.
Good afternoon, Your Honor. Walmart called Lisa Perry.
Okay. All right, please raise your right hand, Ms. Perry. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Counsel, you may ask.
Thank you, Your Honor. Ms. Perry, would you please state your name and business address for the record?
Sure. My name is Lisa Perry, and my business address is 2608 Southeast J Street, Bentonville, Arkansas, 72716.
And by whom are you employed and in what capacity?
I'm employed by Walmart Incorporated as senior manager in the energy department.
And Ms. Perry, are you the same Lisa Perry that caused to be filed in this docket on October 7th, 2020, the direct testimony of Lisa Perry consisting of 17 pages of typed question and answers and 2 exhibits entitled LVP1 and LVP2?
Yes, I am.
And do you have any corrections or revisions to that testimony?
I have one update and one small correction of a typo. So the update is actually the update of the address, which is found on page 1. I need to update that to my current address, which is the one I just gave. It's 2608 Southeast J Street, also in Bentonville. The rest of that's correct. And then 72716, I'm not sure about the 0550 at the end, so I would strike that. And then on page 5, line 20, the sentence that starts with "in light," an "of" should be inserted between the light and the "and," so that it reads "in light of an upward adjustment."
And do you have any other comments or revisions to your testimony?
No, I do not.
If you were asked, was this testimony prepared by you or under your supervision?
Yes, it was.
And would you, if you were asked those same questions today, would your answers be the same or substantially the same?
Yes, they would be.
And would you like to sponsor this as your direct testimony in this matter?
Yes.
Your Honor, I'd ask that the direct testimony of Lisa Perry be marked for the record and admitted into evidence, and she is available for cross-exam.
Okay. Sustained, will be admitted into evidence. And at this time, Ms. Frederick, do you have cross-examination?
No, Your Honor, not for this witness.
Okay, Mr. West or Mr. Cook? Questions?
Yes, Your Honor, just a couple questions, or 3 or 4 questions, actually. Hi, Ms. Perry, how are you doing?
I'm good, thank you.
Do you have your testimony available to you there?
Yes, I do.
Okay. Can you turn to page 11, and starting at line 11, can you read the question and answer that's posed there?
Do you want to read the entire question and answer?
Yes, please.
Okay. If the commission ultimately approves a revenue requirement less than that proposed by the company, what is Walmart's recommendation on revenue allocation? If the commission ultimately approves a revenue requirement less than that proposed by the company, the reduction in the revenue requirement increase should be used for the dual purpose of 1, further reducing the currently existing class subsidies by apportioning a portion of the reduction only to subsidizing late classes, and 2, reducing the impact to all customers by apportioning the remainder to all rate classes. This approach is supported by the company, and then it says see Vaughn Direct, page 9, lines 10 through 12.
Okay, so based on that, if the commission were to approve a revenue requirement that was less than what was proposed by the company, how would Walmart propose that difference be allocated?
You mean, other than what I said, are you asking for like a specific numerical suggestion or just a recent number?
Do you have a specific number in mind?
No, we don't. And that's what I'm trying to clarify.
I'm sorry, I didn't mean to cut you off.
Oh, no, that's fine. I was just saying that's what I'm trying to clarify.
But would it be fair to say that Walmart proposes that if there's a difference between a proposal and what's granted, it and other members of its class should receive a greater percentage of the difference than residential customers?
Yes, this is consistent with Walmart's general support of moving rates closer to cost of service.
Okay. Many of Walmart's customers and employees are also residential ratepayers of Kentucky Power, are they not?
Yes, that is correct.
Okay, so Walmart's proposal then would, in effect, cost that could potentially be borne by it to its customers and employees, correct?
This can be the case, yes, when we move closer to cost of service.
Okay, thank you. That's the only questions I had.
Mr. Kurtz, cross-examination?
Yeah, I think up on Mr. West. The company proposed a $70 million base rate increase. Is that correct? Do you know how much it was?
Yes, I'm sorry.
Mr. Kurtz, I don't think you're up on video right now.
Oh, thank you. You could hear me, you couldn't see me.
I'm a little confused.
The company proposed a $70 million base rate increase.
Yes, that's my understanding.
And the AG and KIUC proposed $43 million approximately.
Yes, that's my understanding.
Of that $27 million difference, how much would you not give to the residential class? Specific number.
You know, I don't have it. Let me back up for a moment. In my recommendation, I intentionally did not attach a specific number to my recommendation because we recognize that the commission is going to consider a variety of factors when determining how much movement should be made towards cost of service. And these factors can include, factors that are very specific to Kentucky and its residents and the times within which we find ourselves. And so basically, I guess to finish that thought, but didn't finish. But so basically, I'm not matching numbers because I recognize that the commission is going to take into consideration many factors, some of which I may not even be privy to.
Well, what value is your recommendation if there's no specificity?
Basically, it's a recommendation as a principle, as an additional way to move closer to cost of service. I did not feel that a specific number was necessary because, like I said, I believe that the commission will be taking into consideration factors, some of which that I may not even be aware of, and I did not want to put out a number where I did not necessarily have all those factors. That makes sense.
I found it. You make this recommendation all around the country, don't you? Same basic testimony?
It has a lot of the same elements, but certainly we review each case individually and make our recommendations based upon that review.
Well, individually in this case, but you don't have a recommendation other than the general premise.
Right.
Thank you, Mr. Chairman.
Okay. Mr. Spinard, questions?
No questions, Mr. Chairman.
Mr. Fitzgerald?
Mr. Chairman, no questions for this witness. Thank you.
Okay, Mr. Miller?
None, thank you, Mr. Chairman.
Mr. Fry?
No questions, Mr. Chairman.
Vice Chairman Chandler?
No questions. Thank you.
Dr. Matthews?
No questions, thank you.
Okay, Ms. Glass, cross-examination?
We don't have any questions. Thank you, Your Honor.
Okay. Ms. Grunman, any redirect?
No, Your Honor.
Okay. All right, thank you, Ms. Perry. You may stand down and be excused.
Thank you.
So I guess that's the case for Walmart, or all the witnesses for Walmart. Next is, Kentucky Solar, Mr. Spinard? I understand you wanted to call another witness out of the listed order, and that'd be fine.
Thank you, Mr. Chairman. We appreciate that accommodation. Casita calls Justin Barnes as its first witness. Okay. Mr. Barnes would join the webcast.
Mr. Barnes, would you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I think you may be on mute, Mr. Barnes. We couldn't hear you.
Oh, is that better? Can you hear me now?
Yeah, I can.
I do.
I read your lips, and they said I do, so that's fine. Mr. Spinard, you may ask.
Thank you, Mr. Chairman. Please state your name and your business address.
My name is Justin Barnes. My business address is 1155 Kildare Farm Road, Suite 202, Cary, North Carolina.
And by whom are you employed in connection with this proceeding?
I'm the Director of Research at EQ Research, LLC.
And on behalf of Kentucky Solar Industries Association, Inc., did you prepare pre-filed direct testimony and responses to requests for information that have been filed into the record in this proceeding?
I did.
And did you prepare an errata sheet for your direct testimony containing 2 corrections and changes to your direct testimony that was filed into this proceeding on November 12th?
I did.
And is the information in the errata sheet true and correct to the best of your information, belief, and knowledge on reasonable inquiry?
It is.
And if I were to ask you the same questions today that are in your pre-filed direct testimony as corrected by the errata sheet, and the same questions in your responses to requests for information, would your answers be the same today?
They would be the same.
Okay, thank you. And Mr. Chairman, at this time, Cassia tenders the witness for cross-examination.
Okay. Ms. Frederick, cross-examination.
Yes, thank you, Your Honor. Good afternoon, Mr. Barnes.
Good afternoon.
In your direct testimony, you recommended a minimum contract term of 10 years for qualifying facilities. Can you explain why you believe a minimum term of 10 years is appropriate?
Well, there's a couple reasons. One, a minimum contract term helps implement what I would call the ratepayer indifference principle. That is that, ratepayers are indifferent to whether a utility is making an investment to secure capacity and energy to meet its load needs, or whether it's, buying that basically from another party like a QF. And the reason a long-term commitment is appropriate is because, when a utility like Kentucky Power is building a facility, once that facility gets placed in service, it's effectively a long-term commitment. And, Kentucky Power is not going to be subject to, say, variations in energy costs in the PJM the way a QF would be if you were to not include a long-term contract requirement. Another reason is that, one of the basic underlying principles of PURPA was to support, some level of certainty in investments. And a long-term contract, be it of 10 years or 15 years or 20 years, as you see in some states, is a way to do that because, without that kind of commitment, it's very difficult for a qualifying facility to obtain financing without kind of a guarantee of revenue, or some level anyway.
Thank you very much for your answer. Mr. Chairman, I have no further questions for this witness. Thank you.
Mr. West, any questions? Mr. West, are you there?
Yes, I am.
Oh, Mr.
Mr.
Horn.
Horn will be handling the cross for this witness. Thank you.
Thank you.
Apologies for being tardy, Your Honor. I was pressing the wrong button, but we do not have any questions for this witness. Thank you.
Okay, thank you. Mr. Kurtz, questions?
Chairman, no questions.
Ms. Grunman, questions?
No questions, Your Honor.
Mr. Fitzgerald?
No questions, Your Honor. Thank you.
Mr. Miller?
No questions. Thank you, Mr. Chairman.
Mr. Fry?
No questions, Mr. Chairman.
Vice Chairman Chandler?
No, I have nothing for Mr. Barnes. Thank you, Mr. Barnes.
Dr. Matthews?
I don't have any questions for this witness. Thank you.
Hey, cross-examination, Ms. Nguyen?
No cross-examination, Your Honor. Thank you.
Okay, Mr. Spinard, any redirect of this witness?
No, Mr. Chairman.
Okay, thank you. Mr. Barnes, you may step down and you're excused. Mr. Spinard, will you call your next witness?
Yes, Mr. Chairman. The CA calls James M. Van Nostrand to the stand.
Okay, Mr. Van Nostrand, would you please raise your right hand? Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Spinard, you may ask.
Thank you. Please state your name and your business address.
James M. Van Nostrand, West Virginia University College of Law, 101 Law School Drive, Morgantown, West Virginia, 26506.
And by whom are you employed in connection with this proceeding?
I'm employed as an energy policy expert by EQ Research.
And on behalf of Kentucky Solar Industries Association, Inc., did you prepare pre-filed direct testimony and responses to requests for information that have been filed into the record in this proceeding?
I did.
And did you prepare an errata sheet for your direct testimony containing 2 corrections and changes to your direct testimony and that has been filed into the record in this proceeding.
I did.
And is the information contained in the errata sheet true and correct to the best of your information, belief, and knowledge upon reasonable inquiry?
Yes, it is.
And if I were to ask you the same questions in your pre-filed direct testimony as corrected by the errata sheet, and the same questions in your responses to the request for information, would your answers be the same today?
Yes, they would.
Thank you. With that, Mr. Chairman, Mr. Van Nostrand is tendered for cross-examination.
Mr. Frederick, cross-examination?
No questions for this witness, Your Honor. Thank you.
Mr. Horn, Mr. West, cross-examination?
Yes, Your Honor, we have a few questions. Good afternoon, Mr. Van Nostrand. How are you doing?
Good afternoon.
Would you agree that a utility customer with installed solar generation gains a benefit regardless if a utility purchases any of their excess power?
I missed that question. Did you say confers a benefit?
Well, if a utility customer has installed solar generation, do they get a benefit regardless if the utility purchases any of their excess power?
They have the benefit and the extra reliability of providing themselves with a power supply. Yes.
Thank you. Do you agree that there's a cost to utilities in providing a service to a customer with solar generation?
To the extent the solar generation does not meet the customer's entire needs at all the time, and yeah, to some extent, the customer will be leaning on the utility, and those costs associated with doing that need to be supported by, the rates for providing that service need to be supported by a cost of service study.
Do you agree that there's a cost to utilities in receiving and using excess power generated from a customer with a solar installation?
I suppose there are some costs. It seems to me the benefits probably exceed the cost, but yes, there are some costs.
Well, putting aside for a moment the political and public relation reasons the utility would offer net metering, if we just looked at net metering from a purely economic approach, what is the benefit to a utility in offering net metering to a customer?
Well, the policy decision made by legislatures over the last 10 years supporting net metering was basically to discourage customer-sided generation. And net metering was a fairly simple and elegant way of doing that by tying the compensation to the retail rate. The grid receives substantial benefits from a net metered customer: capacity, energy, locational benefits that might reduce loads in a certain constrained area, environmental benefits to the extent they're displacing carbon emitting resources, potential just load reduction in transmission and distribution infrastructure to the extent the generation is being produced closer to the load, so you don't have to transmit it over longer distances. There's substantial benefits. And there's also the resilience value to the grid, which I've written a couple articles about. There's no question that the distributed energy resources confer value to the grid.
Do you agree that under net metering that non-participants in solar generation are subsidizing those customers that are net metering participants?
I think that depends on whether the cost of service studies substantiate that. I know that's an allegation made by the electric utility industry, the use of the term cost subsidization, but I think you need to determine what are the values of the DERs provide to the grid and compare that to the compensation they receive and see if there's a match. If they provide benefits that correspond to the level of contributions, no, there's no cost subsidization by definition.
Well, that's all the questions I have, Mr. Chairman. Thank you, Mr. Von Nostrand, for your answers. Appreciate your time.
Thank you.
Mr. Kurtz, cross-examination?
Yeah, I guess so. Good afternoon.
Mr. Kurtz.
How much is the investment tax credit that the federal government gives to rooftop solar installations?
I believe it's 22% and it's ramping down.
So that would be an incentive that the federal government already gives to rooftop solar to encourage the installation of those facilities?
It's an incentive that was determined to be necessary by Congress in connection with promoting the production of renewable energy, yes.
How much does a typical rooftop solar residential installation cost?
It varies substantially from state to state, depending upon the penetration, depending upon the number of solar developers within a state. Those costs have declined 90% over the last 10 years, but no, it would depend on the number of kilowatts of a particular installation.
Give me a typical Eastern Kentucky installation.
I'd have to defer to Mr. Barnes on that. The specifics of the cost, I'd defer to Mr. Barnes on that.
It's thousands of dollars, isn't it?
It sounds what?
It's thousands of dollars.
Yes.
I've heard numbers 8,000, 9,000, 10,000, 12,000. Is it in that range?
Yeah, I think it depends on the number of kilowatts. And of course, the availability of power purchase agreements would ease those upfront costs for customers choosing to install solar, but I don't believe those are allowed in Kentucky.
So to the extent, if the rooftop solar is getting subsidized by other ratepayers, make that assumption, then it would be a subsidy to relatively wealthy ratepayers, because only relatively wealthy ratepayers can afford a $10,000 solar installation. Do you agree with that?
I don't know that the company has presented any evidence to that effect. There aren't that many installations on Kentucky Power's system, so I don't know that they've done a study in terms of what the economic characteristics are of the customers who have solar installations.
Somebody living in a mobile home is not likely to have an extra $10,000 lying around to invest in rooftop solar, are they?
I'm in no position to make a guess about that, Mr. Kurtz.
Thank you, sir.
Ms.
Thank you.
Gunman, questions?
No, Your Honor.
Mr. Fitzgerald?
No questions for this witness, thank you.
Mr. Miller?
Thank you, no, Your Honor.
Mr. Fry?
No questions, Mr. Chairman.
Vice Chairman Chandler?
Yeah, just a couple. Thank you, Chairman. Can you hear me, Mr. Van Nostrand?
Yes, I can, Vice Chairman Chandler.
Can I just ask, how closely have you read the FERC's PURPA NOPR docket?
Order 872, all the proceedings there.
Okay, so did you read Kentucky's, the Kentucky Public Service Commission's comments on the proposed? I guess proposed is redundant, but on FERC's NOPR?
No, I'm sorry, Vice Chair, I did not.
Okay, so as it relates to the change, I guess it's technically a change, or at least a specific direction on the subject of whether or not LMP is a reasonable measure for the avoided cost of energy. You're aware generally of FERC's comments and conclusions on that, right?
Yeah, and Commissioner Glick's dissent on that point as well, yeah.
So can I ask, do you have a position, or does KYSEIA, I think that's right, have a position on if a commission decides to use LMP as an avoided energy cost, whether it's appropriate to use the generator LMP or the load LMP?
I think one of the clear takeaways from Order 872 and the way PURPA has been implemented since its inception in 78 is that states have considerable discretion in terms of how they want to define avoided costs, and there's very little recourse to challenge what a state does. It's much discretion is granted to the states in terms of how they want to set avoided costs.
Yeah, and I mean, as I understand it, FERC said that the commission can set, any commission can set it at generator or load LMP. I'm just curious if you have a perspective as to, I mean, you spoke to the avoided costs, and particularly that the commission's change on purpose. So I'm just curious if you have a recommendation or a position, given the organization's concerns about Kentucky Power's cogen tariffs.
Well, I think I want to reiterate some of the points that were made by Mr. Barnes with respect to the use of short-term marginal costs and LMP is that it's that you don't have a ratepayer indifference in that situation because you're not treating them similarly with respect to not recognizing the longer term costs. So I think I don't think that the LMP it's a short-term cost that doesn't capture all the benefits the DER confer on the grid.
Okay. The organization, is it okay if I refer to KYSEIA as an organization? Sure. Okay. The organization also took a position that you referenced in your testimony regarding Kentucky Power's proposed tariff, the SPP cogen tariff. When there's a legally enforceable obligation, have you reviewed Kentucky's regulations on small power production, which is 807K or 5054?
Yes, I have.
Okay, so when you were talking about that specifically, were you referring to the sections that talk about how rates for power offered on all, I'm shortening here, but all LEOs shall be based at the option of the QF on either avoided costs at the time of the delivery or avoided costs at the time the legally enforceable obligation is incurred?
Yes.
Okay, so let me ask this, and this is something I'm trying to get my hands around. If the commission determines that LMP is a reasonable measure of avoided energy cost, and a utility has a LEO, right, and the minimum contract term is 10 years, what is the organization's recommendation as to the appropriate energy cost if the entity wants to choose it at the time the LEO is incurred? How do we grapple those two what would otherwise seem to be opposite considerations?
I don't know that I've discussed this particular issue with the organization. I think consistent with Mr. Barnes' testimony as far as ratepayer indifference, you want to treat the cogen the same that you would treat the utility, and I don't know that the utility would build something based on the LMP. There's a longer term aspect of it, so it needs to be something higher than the LMP to make it consistent with the 10-year contractual commitment. I think that's the point that Mr. Barnes was making that I agree with, that the importance of the legally enforceable obligation is it recognizes the long-term aspects of a distributed energy resource. It also recognizes and that's a practical matter, the financeability of those resources if you have a long-term commitment. I don't think LMP captures that.
Okay. And the last question I have is as it relates to LMP versus, I think you quote the commission's, let's say the 1980-something investigation into avoided cost rates. Do you remember the portion of your testimony that?
Yeah, June 28th. Yeah, case 8566. Yeah.
Yeah. Do you know what? Let me find what page that's on.
It's on page 13 of my testimony.
Perfect. The last sentence of that, I think it starts on line 10. With respect to avoided energy costs, the order states that such rates, quote, would be equal to the cost of operating the most expensive unit online in the relevant time period. So, and correct me if I'm wrong, I think of LMP as the prevailing rate, right? It's the next kilowatt hour served. would be most likely at whatever the load LMP is. My question is it your all's position that there is a distinction between the avoided energy cost for the highest unit available and the energy cost to serve the next kilowatt hour of demand?
I mean, I think your question presumes that the utility is going to get its next kilowatt hour of electricity from the wholesale market, and therefore LMP is the relevant reference point. And I think the point of that reference to that case, and I put together avoided cost filing when I first started practicing law back in the 80s, in terms of the duty of the utility to show where would you get your incremental cost of energy but for this resource. I think it's a fact-specific situation, and the commission here was giving some guidance, at least as conditions existed in 1984, in terms of how that calculation should be done. But again, I go back to the ratepayer indifference that you need to treat the cogen facility in a manner similar to the utility were building its own facilities to acquire that next unit of energy, and LP does not capture that.
But the commission's not going to build the commission's not going to build generating capacity or a generator to serve the next unit of energy, right? The presumption of avoided energy cost is that it has the capacity available to serve its current system, and what the cost of the avoided energy cost is. The looking at the next generator built would be the avoided capacity cost, right?
Yes.
Okay. That's all the questions I have. I appreciate it, Mr. Van Ostrand. Thanks, Chairman.
Thank you, Vice Chair Chandler.
Dr. Matthews?
And
Ms. Blend, cross-examination?
Thank you, Your Honor. Good afternoon, Mr. Van Nostrand.
Good afternoon.
You would agree that net metering customer generators in Kentucky Power service territory connect behind the meter?
Yes.
And similarly, PURPA QF in the company service territory connects behind the meter?
Yes.
Under those circumstances, when you're talking about behind the meter interconnection, is there a difference between the point of generation and the point of load for purposes of, thinking about the avoided cost of energy under the Commission's Order 877, the FERC's Order 877?
Between the point of interconnection and, what was the question? I'm sorry, could you repeat the question for me?
Sure, I'll state it more clearly. You recall your discussion with the Vice Chairman about the LMP at the generator versus the LMP at the LSC?
Yes.
The load. Aren't those 2 points the same point when we're talking about behind the meter for QF facilities or behind the meter net metering? Isn't the point of generation the same as the point of the load?
I believe that's generally true, yes.
Is there a distinction between energy and capacity in terms of avoided costs under PURPA?
Yes.
I have no further questions. Thank you.
Mr. Spinard, redirect?
No, Mr. Chairman, no redirect.
Thank you, Mr. Nostrand. You may step down and you're excused.
Thank you.
Mr. Spinard, you have another witness?
Yes, Mr. Chairman, Cassia at this stage calls Benjamin Inskeep.
Mr. Inskeep, are you with us?
I know he was on earlier today. There we go.
Apologies for the delay.
All right, Mr. Inskeep, please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. You may ask, Counselor.
Thank you. Please state your name and your business address.
Benjamin D. Inskeep, 1155 Kildare Farm Road, Suite 202, Cary, North Carolina, 27511.
And by whom are you employed in connection with this proceeding?
I am a Principal Energy Policy Analyst at EQ Research, LLC.
And on behalf of Kentucky Solar Industries Association, Inc., did you prepare pre-filed direct testimony and responses to requests for information that had been filed into the record in this proceeding?
Yes, I did.
If I were to ask you the same questions in your pre-filed direct testimony and the same questions in your responses to requests for information, would your answers be the same today?
Yes, they would.
And with that, Mr. Chairman, Cassia tenders Mr. Inskeep for examination.
Okay, thank you. Ms. Frederick, cross-examination?
No questions for this witness, Your Honor. Thank you.
Okay, Mr. Horn, questions?
No questions, Your Honor. Thank you.
Mr. Kurtz?
No questions.
Ms. Grunman?
No questions.
Mr. Fitzgerald?
Mr. Chairman, no questions from this witness. Thank you.
Mr. Miller?
No questions from Sierra Club, Mr. Chairman. Thank you.
Mr. Fry?
No questions.
Vice Chairman Chandler?
Yeah, I have nothing for Mr. Inskeep. Thank you.
Dr. Matthews?
I don't have any questions for this witness.
Ms. Blend, cross-examination?
No questions, thank you.
I would say ask Mr. Spinard if there was any redirect, but since there was no cross, I assume you have nothing to
That's
ask
correct.
the
No.
witness, right? All right, thank you, Mr. Inskeep. You may step down and you're excused. I guess that brings us to Mr. Fitzgerald's case on behalf of joint intervenors. Mr. Fitzgerald, are you ready to call a witness?
I am, Mr. Chairman. I was called Joshua Bills.
Okay, thank you. Mr. Bills? Oh, I think yeah, it's
let's
sort of
see.
dark.
Am I-
Mr. Bills, are you there? Okay, good. Please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? You do.
I do. I just muted my phone, and that's why you couldn't hear me, and now I've got my computer.
All right, that's fine.
Let me see if I
You're
can fix
fine.
that really quick.
Mr. Fitzgerald? You may.
Thank you, Your Honor. Would you state your full name, your place of employment, and your business address, please?
Okay, let's see if I can hear you now.
Would you state your full name, your place of employment, and your business address, please?
My full name is Joshua Daniel Bills, and my place of employment is Mountain Association, and that address is 433 Chestnut Street, Berea, Kentucky.
All right. Thanks. Mr. Bills, did you cause pre-filed direct testimony to be filed in this case?
I did, yes.
Okay, and did you also answer data requests that were served upon the joint interveners?
Yes.
If I asked you the same questions as were asked in your pre-filed testimony, and if I asked you the same data requests, would your answers be the same?
They would be the same. I wanted to apologize because my testimony wasn't paginated, and so I have numbered it now. If we come up to have any questions by page, I'll be able to reference that. So,
thank you, Your Honor. If the commission or staff would want to, we could submit a corrected paginated version of his testimony at the conclusion of the hearing.
Okay.
Chairman, yes, staff would request that a paginated version be filed.
Yes. Absolutely, Ms. Vissel, thank you. With that, Your Honor, I tender the witness.
Ms. Frederick, cross-examination?
No questions for this witness, Your Honor. Thank you.
Mr. Horn?
No questions for this witness, Your Honor. Thank you.
Mr. Kurtz?
No questions, Your Honor.
Ms. Grunman?
No questions, Your Honor.
Mr. Spinard,
No questions, Mr. Chairman.
Mr. Miller,
Mr. Chairman, no questions. Thank you.
Mr. Fry,
No questions, Mr. Chairman.
Vice Chairman Chandler.
I just have one question. Thank you, Chairman, or one set of questions. Can you hear me, Mr. Bills?
Yeah, I can hear you.
I wanted to ask specifically, you raised a concern in your direct testimony in this case around the issue surrounding Delta three-phase customers and interconnecting generation equipment and then service upgrades to those three-phase meters. Or you know what I'm talking about?
I do, yeah, and yes, I do know what you're talking about.
Could you, I'll just be honest, not being an engineer and not knowing my way, if I don't like getting shocked, so I just stay away from anything with current. Could you explain what your concern is, and then as it relates to your concern, what the reference to the increase in cost was? I think it was like $5,000, the increase in cost that you referenced in your direct testimony.
Yes, I know of two applicants that applied for net metering service in Kentucky Power Territory that were not granted interconnection without upgrading their Delta service to a WISE service. And the cost for one was that it was right at about $5,000, subject to check, and the other was around $4,000, also subject. Exactly.
What is Y service?
So that's a transformer service where the connections on the three-phase service are wired in such a way that you will get 240, 277 volts or higher voltage, and with the Delta you get a 120, 208 voltage.
Okay.
So it's a different type of phase.
And so let me ask, are these, I'll ask as clear as I can. These are not residential customers, is that right?
Well, I do know of one residential class customer that has applied for service that is a three-phase customer. They're trying to get their internet operational, and they fortunately do have a WISE service, so this issue hasn't come up for them.
Okay. Is this issue generally reserved though for commercial customers, general service, or for other commercial customers?
I think in the grand scheme of things, yes. I don't know how many three-phase residential service customers Kentucky Power has, but if somebody has a home shop, they may have a three-phase service if they've got an equipment shop serving their residential account service.
Okay. In your experience or the concern that has been conveyed to you on this particular issue is exclusive to Kentucky Power? Do I understand the testimony right?
I haven't experienced this with any other utility installs. I am aware that some utilities outside of Kentucky Power that have a customer that's has a Delta service can satisfy the grounding requirement by having a grounding conductor to serve that the inverter that's attached to that service. So instead of replacing the Delta transformer service, it would just be a grounded conductor added from the transformer bank on the high side to the ground component of the inverter.
Boy, that's a lot of words that I don't use every day.
I imagine this will come up in the interconnection guidelines case, and it just, my reason for highlighting it was there are aspects to the interconnection guidelines case that I think come to play when we're considering what an appropriate compensation rate should be for a net metered customer.
Yeah, I appreciate that, Mr. Bills. Thank you very much.
Okay.
Dr. Matthews, questions?
I don't have a question.
Okay, Ms. Bland, cross-examination.
Yes, Your Honor. Thank you. Good afternoon, Mr. Bills.
Good afternoon.
Mr. Bills, have you reviewed the rebuttal testimony of company witness West with regard to the issue you were just discussing with the vice chairman, Delta three-phase service versus Y three-phase service?
Yes.
Do you dispute that there is a safety issue that really is related to the utilization of Delta three-phase service for 120 to 240 interconnection with net metering customers?
I don't dispute it, but I also don't agree that it requires a change in the transformer bank to satisfy that safety concern.
Okay. And you indicated that you read Mr. West's rebuttal testimony. Do you dispute his statement on page 15 at line 3 that no other AEP operating company allows interconnection of any customer generator facilities to a 120/240 Delta secondary service?
Can you repeat the last part of that?
Sure. On page 15 of Mr. West's rebuttal testimony, he states, at present, no other AEP operating company allows interconnection of any customer generator facilities to a 120 to 240 Delta secondary service. Do you dispute that fact?
I do not.
Now, you just discussed the case number 2020-302, which relates to updating the Commission's net metering interconnection guidelines. And on unnumbered page 7 of your direct testimony, you urged the Commission to hold off on implementation of the company's net metering NMS2 tariff until that case is complete. Is that correct?
That's correct.
So is your recommendation in this case that the Commission delay implementation of the Net Metering Act to Kentucky Power Company's application until that 2020-302 case has completed?
Say that again?
Is it your recommendation in this case that the Commission delay implementation of the Net Metering Act with regard to Kentucky Power's proposed tariff NMS2 until case number 20-302 is completed?
I'm going to interpose an objection. Your Honor, Mr. Bills is not an attorney. He's not holding himself out to be an attorney. And the construction and interpretation of what is required or not required under the Net Metering Act is a matter of law and a matter for briefing, not a matter for asking a witness who is not an attorney.
Sustained. We've had a lot of that. Ultimately, it ought to be briefed, and the Commission will see what the law is.
No problem, Your Honor. I wasn't intending to ask a legal question. I'll ask it differently. Mr. Bills, your recommendation is that the Commission not implement a new net metering service tariff for Kentucky Power Company until the conclusion of case number 2020-302, as stated on page 7 of your testimony, correct?
Yeah, I would suggest not implementing NMS2 as defined.
Thank you. I have no further questions.
Mr. Fitzgerald, redirect?
No, Your Honor, thank you.
Okay, thank you. Mr. Bills, you're excused. Mr. Fitzgerald, call your next witness.
Thank you.
Thank you, Your Honor. I'd like to call Andrew McDonald, please.
Okay, Mr. McDonald, please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, Mr. Fitzgerald, you may ask.
Thank you, Your Honor. Would you state your full name, your place of employment, and your business address, please?
Andrew Scott McDonald. I work for Earth Tools Incorporated, and our address is 1525 Case Branch Road, Owington, Kentucky.
Thank you. Mr. McDonald, did you cause pre-filed direct testimony to be filed in this case?
Yes.
And did you also answer some of the data requests that were addressed to the joint interveners?
Yes.
if I were to ask you those same questions and pose those same data requests to you, would your answers today be the same?
Yes.
Your Honor, the witness is available for cross-examination. Thank you.
Thank you. Ms. Frederick, questions?
No questions for this witness, Your Honor. Thank you.
Mr. Horn?
Yes, Your Honor, a couple of questions. Good afternoon, Mr. McDonald. How are you doing?
Hello, fine, thank you.
Good. Just a few questions. If you were listening to Mr. Von Nosten's testimony, they'll sound quite familiar. Do you agree that a utility customer with installed solar generation gains a benefit regardless if the utility purchases any excess power from them?
Yes,
Do you agree that there's a cost to utilities in providing service to a customer with solar generation?
yes, I agree that there is a cost and that there are also benefits. So whether that cost is a net cost is subject to evaluation.
Understand. Do you agree that there's a cost to the utilities in receiving and using any excess power generated from a customer with a solar installation?
Not necessarily.
Well, putting aside for a moment political and public relation reasons a utility might offer net metering, we just looked at it from a purely economic standpoint. What is the benefit to a utility in offering net metering to a customer?
Well, there are multiple potential benefits of net metering and distributed generation. Mr. Van Nostrum listed some of those benefits. It provides energy capacity, transmission value, offsetting transmission costs, has resiliency value, offsets environmental compliance costs. There is future potential value in offsetting potential carbon costs in the future. Those are just some of those benefits. And the numerous studies and reports have detailed the benefits that accrue to the utility. I have cited a number of those in my testimony.
Thank you. Last question. Do you agree that under net metering that non-participants in solar generation are subsidizing those customers that are net metering participants?
No, I do not. That question is subject to a detailed benefit cost analysis.
Thank you very much, Mr. McDonald. That's all the questions I have, Your Honor.
Okay. Mr. Kurtz?
No questions, Your Honor.
Ms. Grunman?
No questions, Your Honor.
Mr. Spinard?
Yes, Mr. Chairman, we just have a few. Mr. McDonald, currently under NMS 1, residential solar electricity exported to the grid is credited at a 1-to-1 rate. Is that correct?
Yes.
And in approximate terms, the current Kentucky Power Company residential energy rate is approximately 9.8 cents per kilowatt hour. Is that correct?
Yes.
And under the application, Kentucky Power proposes a new residential credit rate of approximately 3.66 cents per kilowatt hour, and that will be part of the proposed NMS 2 tariff. Is that correct?
Yes.
Okay. And in terms of the testimony and in terms of your understanding, Kentucky Power Company describes or characterizes the current 1-to-1 rate under NMS 1 as creating a subsidy. Is that your understanding?
That is how Kentucky Power characterizes it, yes.
And in rough terms, approximate terms, what's described as a subsidy is approximately 6.1 to 6.2 cents per kilowatt hour. Does that sound right?
Yes.
Okay. Have you performed any calculation for the test year of the monthly cost to non-participating residential customers associated with this so-called subsidy?
Yes, I have. And that's provided, it was provided in that testimony.
Okay. And for the purposes of the hearing, what is the monthly cost to non-participating residential customers?
Objection, Your Honor. Mr. Spinard is engaging in friendly cross-examination, which I don't believe is appropriate for this proceeding. Mr. McDonald and Mr. McDonald's organizations that he's representing and CASIA, which Mr. Spinard represents, share a common interest and goal in this case. The company opposed the intervention of multiple groups representing solar interests earlier in this proceeding, and that motion was overruled and denied. However, I don't believe it's appropriate for one solar interest to supplement the record or support another solar interest testimony under the guise of cross-examination.
Yeah, I understand your position, but the motion is overruled. You may ask, Mr. Spinard.
Thank you, Mr. Chairman. And the record, try to get back to the record. What we would like to do is put in context, what is the approximate monthly cost to a non-participating residential customer?
My analysis determined that the monthly cost of this alleged subsidy would be 0.4 cents per month to each residential customer.
And as a final question, what does that, if you know, what does that calculate out to on an annualized basis?
That would work out to approximately 5 cents per year per customer.
Thank you, Mr. McDonald. And with that, CASIA has no further questions for this witness.
Thank you. Mr. Miller?
Thank you, Your Honor. Sierra Club has no questions.
Mr. Fry?
Thank you, Mr. Chairman. No questions at this time.
Vice Chairman Chandler?
I have no questions. Thank you, Mr. McDonald.
Dr. Matthews?
I have no questions. Thank you.
Ms. Bland, cross-examination?
Yes, Your Honor. Mr. McDonald, the study that you just referenced during the friendly cross-examination by Mr. Spinard, was that an analysis that you performed or one that Carl Rabago performed in connection with a 2019 case before the commission?
Carl Rabago provided that study in his testimony, and I updated the figures in it based on the data that was provided by Kentucky Power in this case.
Mr. Rabago is not a witness for any party testifying in this proceeding, correct?
That's correct.
I have no further questions. Thank you.
Mr. Fitzgerald, redirect?
No, Your Honor, thank you very much.
Okay. Thank you, Mr. McDonald. You may be excused. Mr. Fitzgerald, why don't you call your next witness?
Mr. Chairman, at the risk of getting us out of here at a reasonable hour, I am going to call our last witness, James Owen.
Okay. Thank you. Mr. Owen? And Mr. Fitzgerald, in a court, you know, the judge would ask the bailiff to go out in the hall and see if he could find the witness. We'll wait a few
Your Honor, I was just thinking of Joe Pesci in My Cousin Vinny. I'm going to run out in the hall and see if he's on the phone somewhere. The last I heard, he is available to testify.
Okay.
So I will send him an email right now and ask him to make himself present.
I'll tell you what, it's 20 after 2. Why don't we take a 10-minute break or so and give you time to see if you can find him, okay?
That is very gracious of you, Mr. Chairman. Thank you very much.
We'll be back about 2:30. Okay, it looks like we're back on the record. Mr. Fitzgerald, looks like you found Mr. Owen, correct?
Did. After great searching, we had several dog sleds out looking for him, and we were able to track him down.
Yeah, you got him treed out there in the back, okay. All right.
Absolutely.
Mr. Owen, please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, Mr. Fitzgerald?
Thank you, Your Honor. Would you state your full name, your place of employment, and your business address, please?
Sure. My name is James Matthew Owen, O-W-E-N. I am the Executive Director of Renew Missouri Advocates. We are located at 409 Vandiver Drive, that's V-A-N-D-I-V-E-R, in Columbia, Missouri, with a zip code of 65202.
Thank you. Mr. Owen, did you cause pre-filed direct testimony to be filed in this case on behalf of the joint interveners?
I did.
And did you also answer some data requests that were posed to the joint interveners?
I did.
And if I were to ask you those same questions and pose those same data requests to you today, would your answers be the same?
They would.
Your Honor, I tender the witness for cross-examination. Thank you.
Okay, thank you. Ms. Frederick, questions? Ms. Frederick?
Sorry, Your Honor, I was having a little bit of technical difficulty. No questions for this witness. Thank you.
That's fine. Mr. Horn?
No questions for this witness, Your Honor. Thank you.
Thank you. Mr. Kurtz?
No questions, Your Honor.
Ms. Grunman?
No questions, Your Honor.
Mr. Spinard?
No questions, Mr. Chairman.
Mr. Miller?
No questions. Thank you, Mr. Chairman.
Mr. Fry?
No questions, Mr. Chairman. Thank you.
Vice Chairman Chandler?
Yeah, thanks, Chairman. I have no questions for Mr. Owen. I appreciate it.
Dr. Matthews?
I have no questions for Mr. Owen. Thank you.
Okay, Ms. Bland, cross-examination?
No questions, Your Honor. Thank you.
Okay, I guess, Mr. Fitzgerald, that makes it a pretty easy direct exam and no redirect. Thank you, Mr. Owen.
It does, Your Honor. Thank you.
Thank you, Mr. Owen.
Yeah, thank you.
You
Thank you, Your Honor. Sorry about not being online earlier.
Oh, that's no problem, believe me. Thank you, you've been excused. Now, is that the case?
Thank you.
That's all the witnesses for joint intervenors, correct?
Yes, Mr. Chairman, I've just moved their direct testimony into evidence, and I appreciate very much giving us the break that you did so that we could finish our case.
Yeah, well, that's sustained. And now, there's one a person who was not a witness who had, I guess, some, I don't know, his testimony may not have been sworn to, Mr. Rabideau. His testimony is not into evidence because he was not a witness. What he said is filed and is subject to consideration, but was not formally a witness. Now, that brings us to, I guess, Vice Chairman Chandler wanted the opportunity to recall Mr. Madison. And is that still the case, Mr. Chandler?
No, I think that with the testimony we've had today, I don't think that I have any questions for Mr. Madison based off of what we heard from AGKIUC's witnesses as well as the joint interveners in Walmart and as Mr. Spinard has helped me out a little bit at CASIA.
So I guess
it's much easier than saying KYSEIA every time. So I appreciate that, Mr. Spinard. But I don't have any follow-up questions based on today's testimony from Mr. Madison. Thank
you, Mr. Madison. I'm sorry you had to be available, but that's the way it is in legal proceedings. Sometimes a party or a lawyer doesn't know whether you need somebody or not until all the testimony is completed. So you may be excused, and thank you for being here and for your testimony. That concludes all the testimony, but Ms. Vinsel, I think, had a motion to make for the record. Is that correct? And if so, would you do so now?
Yes, thank you, Chairman. Staff would like to move that the record from case number 2019-00256, this is the electronic consideration of the implementation of the Net Metering Act, that be incorporated into the record of this proceeding by reference. Several of the parties have referenced this in the final order in 2019-256. We indicated that the record from that proceeding would be incorporated into all initial net metering rate-making cases.
Right, well, your motion is sustained, and the record in that case will be incorporated into the record in this action. All right, is there anything else that, any other matter that council would like to bring up? Mr. Spinard?
Yes, Mr. Chairman, I apologize. I believe I missed this point earlier. To the CASIA witnesses have been tendered for examination, and to the extent that we need to move for their testimony and their responses to be admitted, to be accepted by the commission, we so move.
Well, all witnesses will be, have been accepted and admitted. There hasn't been any, no one's contested, no one's asked for a Daubert hearing. And of course, the direct testimony was already filed. So all of the witnesses who've been listed are properly before the commission, and their testimony is accepted for what it is. Okay?
Thank you, Mr. Chairman.
Anything else that anyone would like to bring up before we adjourn? Ms. Blend, anything?
Not for the company, Your Honor. Thank you very much.
Okay. Any of the other parties? No?
Mr. Chairman, just wishing everyone a happy Thanksgiving and appreciate being able to participate in this proceeding.
Okay, thank you. The order, we only have probably less than a half a dozen people here in the office. I have the order typed up on the scheduling, but we've now gotten to the point where we can't sign paper. We only sign on a computer screen. So I'll see if we can get that out by tomorrow at any rate. But I've given you all the dates, and if you'd like for me to read them again, I'd be happy to. Data requests due by the end of the day, December 1st. Responses due December 9th. Kentucky Power's brief December 8th. Brief for the intervenors due December 14th with a reply brief by Kentucky Power on December 17th, and the case will stand submitted 12:01 a.m. on December 18th, 2020, and we'll be working as hard as we can to get a decision. All right, Mr. Grumman, it's good to see your co-counsel. It's always good to have experienced co-counsel to assist in these things. So.
Well, he wanted to thank you for your hard work on this hearing and wanted to wish everybody a happy Thanksgiving.
All right, same to you all. All right, with that, then this hearing is adjourned. Thank you.
Thank you.
Thank you.